Lordship, my lord. On by Thursday, Your Lordship allowed us to mention the charter matter, item 46 in the solvent to be taken at 2. It may taken at 2, my lord.
56,
46, my lord.
46.
46. Lordship has heard the matter.
46.
Yes.
All right.
At 2, my lord.
At the end of the part 1 list
Yes.
or 2:30 like that?
Yeah, at 2, my lord. Completely.
Ah.
Yes. Oblige, my lord.
My lord, for listing, my lord, these two matters, my lord, in one matter, my lord, we have challenged one order, there is no, my lord, interim order, my lord.
You want it for listing,
Yes, my lord.
admission matters, right? Can it not be in January,
My lord, on Wednesday, my lord,
Wednesday? Why?
because there is no interim order and after some days it may become infructuous also.
All right, Wednesday.
And there is another
Both
Yes.
on Wednesday? Admission matter?
admission.
My lord, I am before mentioning, well, I am sorry to say, my lord, this matter was listed on Friday.
Ah.
I could not appear, my lord. Can it be taken up today, my lord?
Is it listed?
Not listed, my lord.
Then it has to be on Wednesday.
My lord, I have another prayer, my lord. In this case, the petitioner was placed on the suspension. DP has been completed. She has been imposed with punishment of 3 increments, my lord. But she is yet to be reinstated. Both the matters will be taken up on Wednesday, my lord.
All right, Wednesday.
Obliged, my lord.
May I please, sir? I'm praying for listing of a petition lordship on, as per lordship's convenience only, because this is a pension matter lordship.
Pension
Not
matter.
listed for last 1 year lordship.
Let it be on 7 January.
7 January.
May I please, Lordship, my lord, motion matter, my lord, file on my lord 26/11, my lord. Maybe on Wednesday, my lord.
26/11.
Oblige.
Was filed on 26/11.
26/11, my lord. Oblige.
Wednesday.
Lordship, one admission matter, may prefer on 10th of December.
10th of December.
Yes,
Why 10th?
Lordship, the pension related matter, Lordship, area salary, kindly Lordship.
All right, 10th.
This matter was lordship last listed in September 3rd and it was made returnable and after 4 weeks, but it has not been listed lordship. Matter relates lordship non-grant of increments. So lordship, next week in the lordship.
8th
Lordship,
8th of December.
8th of December. Lordship.
Obliged.
Prayer for listing and admission matter.
Prayer for listing.
Pension matter.
Come in January.
In the last, listed on 28/5.
28/5.
Yes,
So
my
let
lord.
it be in January, 7th of January.
That's good.
Your Lordship, I beg to mention for listing on WBC on Wednesday.
Why?
It's a pension matter and
In January.
motion matter.
Motion matter, fresh matter.
Yes.
What is wrong? When did you file it?
25 December.
So it will come if it is clear of defects, it will come.
November, sorry, on
it will come.
November.
It will come on its
No.
own, fresh matter.
On 8.
It will come within 48 hours. Yes.
Maybe it's a lot. I have to mention for one petition for admission lordship.
January, 9 January.
Please, mention for listing of two arbitration petitions, Lordship.
Arbitration notice for admission hearing.
Admission, Lordship.
Let it be in January,
January
9th of January.
9th. Obliged.
May I please, Lordship? Lordship, I beg to mention a new repetition for listing lordship. Or admission lordship,
For admission.
for admission. This Friday lordship,
This
family
Friday.
pension matter lordship.
5th.
5th lordship.
All right.
Oblige your lordship.
Please, my lord, prayer for listing of a fresh motion matter, my lord.
When did you file it?
My lord, 27th of November.
7 November.
27th of November.
So it will come. Why are you mentioning it?
Friday.
Give them some time to work out and list it. They'll have to check for defects. Why are you unnecessarily burdening the system? It comes. Is there an urgency that it has to be done tomorrow, day after? It will come. If it doesn't come for a week, you mention it. All right.
Deeply obliged.
May I please check lordship item number 21. Lordship, 2 weeks time may be granted lordship. We will file a implement petition.
To item 21.
I appear for the respondent, your lordship.
Item 21 on the request made by the counsel for the petitioner stands deferred. to be listed after.
I pay for the sole respondent. Your Honor.
Mr. A. Das appears for the sole respondent.
Obliged.
Placed accordingly after 2 weeks.
Lordship, item 40, Lordship,
4-0.
40, Lordship.
Ah.
Let it come matter, come after week, Lordship.
Item 40, the request of Mr.
Petitioner, Lordship.
Your
MS
name.
Alam.
Your name,
MS Alam.
MS.
Alam.
MS Alam. Matter stands deferred to be listed after 2 weeks.
Obliged.
Also, beg to mention, 2 items for listing in admissions column.
Come in January, 9 January.
Obliged.
My please, Lordship. I beg to mention item number 28 and 29, Lordship. Kindly pass over for that.
28 and 29.
29.
Review petition.
Review petition.
What is your prayer? What do you want?
Lordship, next week.
It will go for 2 weeks. Item 28, 29 on the request made by counsel for petitioner stands deferred to be listed after 2 weeks.
Maybe, Lordship. Lordship, item number 15, our record is lost, Lordship. So we need some time to restore the record.
Item 15.
Yes, Lord.
You are for the petitioner.
I am for the petition.
Item 15 stands deferred to be listed after 4 weeks, enabling the counsel for the petitioner to reconstruct the case record, which reconstruct the brief. So,
Obliged, Lord.
Maybe, Lord. My lord, I have filed this writ petition to get appointment as Anganwadi worker. Earlier, there was advertisement, Lordship may kindly see page 13. And in that advertisement, I was selected. I have passed higher secondary examination. And the other party who was in the top, she did not bear proper health. On the other hand, her personality was not found suitable. And in addition to this, she was found pregnant.
yes,
So, Your Lordship, we have received the instructions and also the additional affidavit. I have to get instructions on the additional affidavit. Your
all
Lordship.
right. Heard Mr. M. E. Mohammed, learned counsel for the petitioner, Mr. D. Bora for the state. The petitioner has filed the additional affidavit as permitted by the court by its earlier order dated 8/4/2025. Accordingly, it is also specified in the earlier order, the matter should be taken up for disposal at the admission stage accordingly. That notice issue. Notice is issued or not?
No, Your Lordship, the question of delay may be kept open. Your Lordship.
Notice issued, returnable 4 weeks. Since the respondents appear, any private respondent?
No, here is no private issue. Sorry, my lord.
Mr. D. Bora appears.
Look,
for
here, one is,
Before, therefore.
but her case has been
waived.
dismissed.
Extra copies be furnished within a period of 1 week from today. Steps on respondent 5 by speed post within 2 weeks from today. Matter be listed for admission after the returnable date.
The Lordship may observe the question of maintainability on the ground of delay.
That was due to tendency of writ petition between the two parties.
Which is raised by the respondents, is left open to be decided at the time of admission.
Highly obliged. Maybe, Your Lordship. Can you see the last order, my lord?
Huh?
Last order, my lord. Mr.
Ah.
Prakash. What was called for?
Any instructions?
Clause 22, next page. That is relevant.
Driving test, not qualified. You're not qualified.
Then no case, my lord. 25 is the my lord qualifying mark.
You got less than that. In fact, they have been benevolent by rounding it off to the nearest
Yes.
whole digit. Heard counsel for parties, this writ petition is filed by the petitioner. Who? submitted his candidature for recruitment of constable driver and constable slash driver cum pump operator within bracket driver for fire services in CISF pursuant to the advertisement dated 3/2/2025 published by the CISF for filling up of 1124 numbers of such vacancies. Stop. Petitioner appeared in the physical efficiency test and physical standard test, which petitioner claims he has successfully completed. Thereafter, the petitioner appeared in the trade test held on 7/11/25, wherein he was declared not qualified in the category of driving heavy vehicles without any marks being allotted or disclosing his name. Stop. Petitioner was furnished with a mere rejection slip dated 7/11/25, which contains the remark within quotes not qualified. Stop. By order dated 24/11/25, the court permitted the learned CTC, MS B. Sharma, to submit the marks available on record. So, whereas today when the matter is called up, the individual record sheet insofar as the petitioner is concerned is placed before the court at serial number 22. The results of the trade test slash driving test is specified, is available. Stop. For the category of driving test for heavy motor vehicle, out of the total marks of 50, the petitioner secured 18.5, rounded off to 19, and was therefore not qualified, as the qualifying marks, minimum qualifying marks is
25.
25. So, where the counsel for the petitioner, in all fairness, submits that this marks was not made known to the petitioner and therefore being agreed. He had approached this court. Stop. Now that the records reveal that the petitioner did not qualify in the driving test for heavy motor vehicle, counsel for the petitioner does not wish to press the writ petition any further. Accordingly, the petition stands dismissed for as not pressed or withdrawal.
Your Lordship may pass order, my lord.
All right. Considering the submissions made, since the petitioner did not qualify in the trade test and has obtained marks which are below the qualifying marks, we don't find any need to proceed further in the writ petition. Accordingly, the same stands dismissed. The individual record sheet placed before the court is returned back to the writ petitioner, to the government counsel. Can we get a photocopy of this? Give us a photocopy. However, the court master will retain photocopy of the same in the case record. Dismissed. So, providing a photocopy at a time.
May I please, your Lordship? Your Lordship, in this matter, your Lordship, I have challenged the very inquiry report, your Lordship, dated, your Lordship, 31/10/2023, 39/2024, and also the punishment order, which is at annexure 13, page number 90 to 91, your Lordship, withholding of,
Page number
page number 90 to 91, your Lordship,
92 to 91.
90 to 91, your Lordship, withholding of one increment without cumulative effect, your Lordship. Here, your
Why not go for appeal?
Yes, your Lordship. I have not preferred the appeal. However, your Lordship, I have pleaded, your Lordship, that non-preferring of the appeal itself would not bar me to challenge the very decision-making process of the respondent authorities, your Lordship.
What is your ground for challenge?
Yes, your Lordship, there are many grounds on which I have challenged your lordship. The primary grounds were the non-consideration of the very defense, and furthermore, your lordship, the presenting officer had relied upon certain
So
documents.
these are things which can be looked into by the appellate authority.
Yes, your lordship, the presenting officer had relied on the day of hearing of the inquiry report, your lordship. The presenting officer on that day itself
Mr.
had,
Counsel,
Yes,
you are
Your
anyway before a court of law.
yes, your lordship.
You are agitating this order.
Yes, your
There is
lordship.
a departmental avenue for that,
Yes, Your
statutory
Lordship.
remedy.
Yes,
So
your lordship.
unless you say that the disciplinary authority was not empowered or the rules were prima facie not followed,
Yes, your
you were
lordship.
not given an opportunity to.
Yes, your lordship. Those are the particular grounds which I have also
Right.
taken under your lordship.
Counsel for party, you should notice. Mr. I. Thakur appears for
Forest Department,
Huh?
all the respondents.
for all the respondents. Therefore, notices are waived, extra copies be furnished within a period of 1 week. Let the respondents complete their instruction and file necessary affidavit if so advised. In the meantime, matter be listed for admission after the returnable date. Question of maintainability be left open.
Yes, your lordship. Your lordship, I have only challenged the decision-making process itself, your lordship. Violation of principles of.
We'll
ethics.
examine that.
Yes, your lordship. Much obliged, your lordship.
Hello. On the petitioner is a head constable, my lord, in the CISF. He was compulsorily retired on 12/9/2024.
Mm.
The order, my lord, is at page 26. The relevant portion, the typed copy is at page 26A. Thereafter, my lord, the petitioner preferred representations before the authority. Thereafter, his appeal, my lord, against the order of retirement was disposed of by the order dated 29/7/2025 that your lordship will find at page 104. 104, my lord.
Yes.
The grounds for challenging order of compulsory retirement, my lord, is very narrow. Unless there are reasons to show that the authorities have not taken a conscious decision to retire the petitioner. If your lordship may kindly come to page 105.
Yes.
105, my lord, this is the representation committee, my lord, which was set up to look after the appeal. If your lordship looks at the first paragraph. Order number so-and-so, Jairam Yadav, formerly of CISF unit SBSS Salakati, was appointed in CISF on 4/7/1994 as constable and thereafter promoted to the rank of head constable GD on 27/2/2019. He was a Group C employee while he was posted at CISF unit SBS Salakati Superannuation Review Committee headed by the DIG/Northeast Zone NEZ, my lord, reviewed his case on 28/3/2024 and found him fit for retention and service on completion of 30 years of qualifying service. My lord, on 28th of March 2024, he was found fit for retention, and in the same year, on 12th of September 2024, he was compulsorily retired, my lord. So the law is settled, my lord, that unless there are compelling grounds within the intermediate 6 months, the CISF could not have exercised that provision of compulsory retiring the petitioner, inasmuch as they had exercised that right in the year 2024 in March itself, my lord, and found him fit for retention. That is my case, my lord. I'm on a very narrow footing, my lord.
Yes.
Lordship, because the superannuation review committee recommended his compulsory retirement because his service record was not up to mark. Lordship, total,
The recommendation,
yes. Lordship, recommendation,
recommendation,
My lord,
recommendation.
my lord, page 26, my lord, the order.
It is the order
That is the
of
initial order
compulsory,
of compulsory retirement, my lord.
compulsory retirement.
And my lord, if your lordship permits me, the representation which was disposed of by order dated 29/7/2025 that I've just read out, my lord. Your lordship may kindly come to page 107. 107.
yes.
107, my lord, 6.2 views comments of the administrative ministry. Your lordship has seen that? 6.2, page 107.
Yes.
Yes, my lord. Point number 3, Roman 3. The performance of the official was reviewed as per the provisions laid down in Rule 48 of the CCS Pension Rules 1972 now 2021, and consolidated guidelines issued by DOPT OM number so and so dated 28/8/2020. My lord, that OM has been appended as Annexure T. It starts at page 109. My lord, the ground under which the authorities have compulsory retired the petitioner can be found at page 111, page 111. Page 111, point number 7. There is also no bar on the government to review any such case again, where it was decided earlier to retain the officer. But the appropriate appointing authorities of the opinion that it is expedient to undertake the review again on account of changed circumstances in public interest. In such cases, the appropriate authority is expected to demonstrate visible meticulousness, as such government servants have been found effective on earlier occasion for retention in service. It is admitted by the government, my lord, the CISF, that he was found fit for retention on 28th of March 2024. Then thereafter, within 6 months, he was retired. So the authorities, with the CISF, my lord, in my humble submission, they have to demonstrate, my lord, sufficient materials within that 6 months to have warranted that order, my lord. That is my case, my lord, because compulsory retirement otherwise is not seen as a punishment, my lord. There are no consequences involved in as much as retirement benefits ought to be granted to the petitioner. But I'm challenging my case only on this point, my lord, that within 6 months, they found me ineligible to continue in service. That is my ground, my lord. If the CISF can satisfy this honorable court on that point, my lord,
Any instructions here?
No, Lordship. Lordship, on 12 occasion, he was awarded punishment. And therefore, his SCR was, his service.
No,
was
everything is
not up-
okay, but you decided to review.
Yes, Lordship, the representation committee has further considered his representation, Lordship, after recommendation by the superannuation review committee. And representation committee has upheld the recommendation of the
So what is the
superannuation
reason?
committee, review committee.
Will you place the reasons why?
a 6-month period might be relevant, my lord.
How much time will you require to get instructions?
Lordship, next week it may be taken up,
Next week,
next week, Lordship.
let us see what
My lord,
instructions come.
my lord, in the meantime, if in a time-bound manner, my lord, the CISF can release my retirement benefits, I have been deprived
Let
of
us,
my.
you wait for next week.
My lord, I'm grateful.
Your retirement benefits, if you are interested, then why are you challenging the?
No, my lord,
release
if this matter proceeds for further hearing, my
order?
lord.
That we can't decide on
My lord,
the first day.
I'm grateful.
You are challenging the release order,
Absolutely.
but you are interested in retirement benefits.
As of now, my lord, because I have been bereft of any pay
So
for
if
the
you are
past
interested
14
in
months, my lord.
retirement, we'll direct them to release it.
No, there is a prayer, my lord, as of now, my lord. I'm grateful, my lord. I'm grateful.
List this matter again on, when can you get it?
Wednesday, Lordship.
Third? Next Wednesday,
Next week,
next Wednesday,
next, yes.
10th.
Alright.
Enabling the learned CGC to complete her instructions in the matter. Although notices are not issued, the counsel for the petitioner will furnish sufficient extra
My
copies
lord,
during the course of the day.
my lord. I'm grateful.
Hmm.
May I please, your lordship? So here, my lord, I was appointed, lordship, as a office accountant, my lord, and in 2001, my lord, in 2019 March, my lord, I remain absent from my duty, my lord. And subsequently, in a NI case, my lord, I was convicted also, and I have undergone, my lord, imprisonment. And after that, my lord, I have, my lord, made an application before the authority to rejoin my service, my lord. They have not allowed, my lord. That is my case, my lord, simply.
Yes, finance,
Lordship.
can you get instructions?
Yes, Lordship. I'll find out, Lordship, what is.
Why he is not being allowed to join?
Yes, Lordship. Lordship, this representation was made on 24, Lordship. Lordship, may I issue notice at this stage, Lordship. I'll get the necessary instruction, Lordship.
So you first give us instructions why he is not allowed to join,
Yes, Lordship.
whether he is terminated from service by way of disciplinary proceeding.
Lordship,
Nothing is here.
Nothing is there.
He doesn't know why he is not allowed to join.
Lordship,
Were you appointed in regular service?
Regular.
Then
Lordship.
third counsel for parties, the grievance of the writ petitioner is that the petitioner was serving as assistant accounts officer in the Assam Accounts Service and under the administrative control, the director of accounts and treasuries Assam. So, according to the petitioner, because of compelling reasons, he remained absent from service from March 2019 and subsequently when he attempted to join, his superiors did not permit him to join. He has filed a representation dated
12/2/24.
page number
Page number 32, annexure 4.
dated 12/4/2024 before the Deputy Secretary, Government of Assam Finance, within bracket ESTT hyphen capital B Department, Dispur. However, the same has remained pending. Where is he supposed to join?
He's saying PH executive, in the office of executive engineer PHE Lordship.
Assistant Accounts Officer in the account under the administrative control of so and so. He was serving in the office of Executive Engineer PHE, Store and Workshop Division, Betkuchi, Guwahati, 3. Then compelling reasons he was absent. The Mr. I. Botakur appearing for the PHE department and Mr. A. Choliha, Learned Counsel representing the Finance Department, are permitted to obtain their required instructions as to why the petitioner not being permitted to join. Extra copies of the writ petition be furnished to the respective counsel within the course of the day. List this matter again on 10th.
May it please your lordship. The matter pertains to non-dispersal of the 50% of the pension, your lordship. The petitioner, your lordship, herein is the son of the deceased father, your lordship, who was an employee in the APDCL, and he is of the son to the second mother. The first wife is still there, your lordship, and she was doing the entire pension. However, the second wife, she filed a
Where is the modification order?
Your lordship, it's in page number 18, your lordship, annexure 4.
What is the meaning of this, Mr. Counsel? Maybe held up?
Next 50% may be held up for the children of second wife till the employment for
Held up by whom?
most only by the authorities, your lordship. I'll take instruction in this.
Huh?
Take instruction in this
Yes.
modifications.
Heard counsel for petitioner is agreed that notwithstanding the order passed by the APDCL authorities modifying the earlier pension for family pension issued in the name of the first wife, Srimati Sobita Bosumatari, issued in the name of Srimati Sobita Bosumatari, first wife of late Ronendra Bosumatari. The 50% of the family pension, which was subsequently altered by the authorities have not been released to the petitioner, who is the son of the second wife of late Ronendra Bosumatra. Mr. Gugoi, Leonard Standing Council, submits that he'd like to complete his instructions in the matter. This matter again on 12th of December. Extra copies be furnished within the course of the day.
Obliged, Lord.
May it please your lordship, my lord, petitioner is praying for disability pension. Says because my lord, he got injury during service and he was invalidated out from.
Can you be a
service.
little louder? It's difficult for me to hear you.
My lord, kindly.
Disability pension,
Yes, my lord.
yes.
Annexa 3, my lord, page 20. He was,
20.
yes, my lord. Petitioner was invalidated out from service on medical ground as because he got injury during service. Page 20, my lord. There are two, my lord, relevant. I'm praying for a notice. In Annexa 6, my lord, page 23, his review medical was also done, my lord, on December 24. Page 23.
Please get instructions. Or, I think it is, we'll have to issue notice here. Third council for parties issue notice returnable for weeks. Petitioner is agreed that the disability pension payable to the petitioner by the some rifles authorities have not been released. Being agreed, petitioner is before this court. MS
P. Rava on behalf of Ms. A. Gayan.
P. Rava appears on behalf of MS E. Gayan. CGC represents all the respondents, therefore notices are waived, extra copies be furnished within a period of 1 week from today. Matter be listed after the returnable date.
May I please?
Yes.
Advertisement for fill up the vacant post of different grade 3 employee Miller. Advertisement page 24 Miller and relevant part is page 25. 48 50 serial number. For the post of Miller, technician assistant for CSS and a technician for CSS Miller. 55 and 48 to total 103 post Miller. In the provisional final list Miller, the respondent authority only 42 candidates were selected. And out of 103, provisional select list is page 35. 34, 35.
Yes, Mr. Obomanno, any instructions?
Lordship, I have the instruction, Lordship. Their marks are way below the cutoff marks, Lordship. Let it come on Friday, Lordship. I'll file an affidavit. There. Lordship, I have the telephonic.
You want to file affidavit, issue notice, right?
Yes,
Let
yes.
council for parties issue notice. Returnable 2 weeks. Mr. D. Upomannu.
For 2, 3 and
Accepts notice on
2, 3 and 4.
2, 3 and 4. Mr. Bora.
1.
Appears for respondent number 1. The Learned Standing Council Health submits that instructions have been received. You'd like to bring them on an affidavit. Let this matter be listed immediately after 2 weeks.
Highly obliged.
May it please your lord. My lord, here lordship, the petitioner being a physically disabled person, lordship, applied responding the advertisement for selection of public prosecutor as well as additional public prosecutor lordship. And in the advertisement lordship, for the additional public prosecutor lordship, one post for physically handicapped person were reserved lordship. And in the additional public prosecutor lordship, four posts,
How many years of experience is required?
lordship, 7 years lordship.
And how many years have you put in?
Lordship, I have, since 2008 lordship, I am in practice lordship.
So, but your certificate of practice is issued in 24.
My lord, that was the lordship, required to renew every 5 years lordship. So updated one I have given lordship. Otherwise lordship, regarding my practice lordship, no dispute is done. Because I am regularly appearing in different judicial forum lordship, as well as before this honorable court lordship. The fact remains is that lordship, there are 4 posts are reserved in the additional public prosecutor category lordship. But only one person were selected lordship, who also selected in the public prosecutor lordship.
Experience 10 years.
So that was the clear violation of the lordship statute.
First you produce, because in the certificate of practice, it is issued in 2/8/24.
Yes, lordship.
There is no reference that this is a renewal certificate.
Because lordship, if
What is
required-
the original?
because I am the regular member of the Guwahati High Court Bar Association also lordship. So I will produce lordship the certificate from the bar also lordship.
No, certificate, this certificate of practice at page number 22
Yes, lordship.
is the certificate pursuant to which you are in practice.
Yes, lordship.
This certificate was issued on 2/8/24.
Yes, lordship.
You claim to have 7 years of practice.
Yes, lordship.
According to you, this is a renewal certificate.
Renewal, sir.
So give us the original certificate by which you had put in the practice till it was renewed by the 2/8/24 certificate.
I will show this.
Bring it on record. I think that certificate would be relevant.
Yes.
Let it be on record.
Lordship.
Lordship, otherwise lordship, that as per the
So this
BCS
is the eligibility.
yes,
First to satisfy that you are eligible. Bring it on record.
I will file through additional review.
Learned counsel for the petitioner craves leave of the court to file an additional affidavit to bring on record the certificate of practice initially issued by the Bar Council of Assam, Nagaland, Arunachal Pradesh and Sikkim. As the petitioner claims that he has put in more than 7 years of practice to make himself eligible for the post of which post?
Additional public prosecutor.
Additional public prosecutor. In pursuance to the advertisement dated 2nd of January 2024 issued by the Government of Assam, Department of Home and Political. Let this affidavit be brought on record within a period of
Next week, definitely.
1 week. Bring it on record. Deeply.
All right.
Petitioner has challenged his termination order, Lordship, whereby he was terminated from service without holding any disciplinary proceeding. The Lordship will find the impugn order at page 34, Lordship.
Page
34, 34,
24.
34, 34. He was terminated on the ground of misconduct and no disciplinary proceeding was initiated, though misconduct was alleged.
My lord will issue notice.
Heard counsel for parties issue notice returning reports. Mr. Hardhor appears on behalf of all respondents. Therefore, notices are waived. Extra copies will be furnished within a period of 1 week from today. Matter be listed after the returnable date.
May I pray for a date, Lordship?
Ninth of January.
Lordship. Can it be on 8th, Lordship? 9th is the last date.
Then
Before-
7th of January.
Lordship, Lordship. Obliged, Lordship.
39.
May please, your lordship. In this case, the petitioner, he was reinstated, my lord. His license, he was reinstated. Well, his license was restored, not restored.
It has not been restored, my lord. Though it was suspended for 6 months. Almost
Yes.
more than one year has passed, my lord.
This is in the register of the Assam
Yes,
Council.
Yes, my lord. And they are not being represented. Well, I'll take
Who
a justice
represents?
service.
My lord, I am for the respondent number 1 and 2, my lord, the National Medical Commission as well as the Ethics and Medical Registration Board, which is a wing of the NMC, my lord. My lord, the primary answering respondent here would be respondent number
3 and 4.
3, my lord. Here.
Who, any council for 3? Is it the health, standing council health who appears? No,
They do not appear, my lord. They do not appear, my lord.
they do not appear. Right, right. Medical registration, you appear, Mr. Chalia?
Lordship, for health, I can appear, lordship, but lordship, our names have not been.
The council for the parties. Petitioner is aggrieved that
The 3, the number 3.
although
Kindly arrange.
his medical license was suspended for a period of 6 months by removing his name from the register of the Assam Council of Medical Registration by order dated 12/7/24, in spite of the 6 months, in spite of expiry of 6 months, his license has not been restored by entering his name in the registrar of Assam Council of Medical Registration. He has filed a representation on 14/11/25, praying for a direction. So, however, no orders have been passed. The Mr.
DK Boyddo, my lord.
D.K. Boyddo appears for respondents 1 and 2. Mr. Chalia?
Lordship, I'll appear, lordship, but lordship, we have not received a copy, lordship, lordship.
Mr. Chaliha appears for respondents number
I have given the
3
copy.
and 4.
I have subbed the copy.
Lordship.
So, therefore, we permit Mr. Chaliha to obtain instructions as to why the name of the petitioner has not been restored in the, why the license of the, medical license of the petitioner has not been restored by entering his name in the register maintained by the Assam Council of Medical Registration. Stopped. Let these instructions be placed before the court on how much? 12th?
12th, lordship.
12th.
12th, lordship.
On 12th. And stop, although notices are not issued, extra copies be furnished to the respective planning councils within the course of the day. Based on 12th.
Deeply obliged, my lord.
May it please, Your Honor. Lordship, on the last occasion, we were supposed to substitute petition number 10. On the recent communication, Lordship, we got to know that the legal heads of the petition number 10 is staying at Dehradun, Lordship. So we seek some time so that we can communicate and take the necessary steps for the substitution, Lordship.
Counsel for the petitioner submits that the legal heirs of respondent number 10. Let Surinder Singh Rawat
Yes, Lordship.
are permanent residents are residing in Dehradun in the state of Uttarakhand. He therefore submits that further time is required to complete the instructions, enabling them to file a proper application for substitution. Mr. K. Kolita appears for the respondents.
Respondent 2 to 6.
2 to 6, is taken after 6 weeks.
Kali.
Item 9.
I tender my sincere apology, Lordship. The step in respect of the respondent number 7 only missed out, Lordship. I will be allowed 1 day's time to take this step.
Sen, learned counsel, hearing for the writ petitioner, submits that by oversight, steps on respondent 7 would not be undertaken, raised for weeks' time to complete steps, to enabling him to undertake the steps as required. Mr. Rahman for respondent?
6, Lordship.
MS Bhattacharya for?
1 to 5.
Respondents 1 to 5. List again after 1 week. 1 week?
Yes, Lordship.
Obliged.
Right.
Item 10.
May I please, Lordship? Lordship, kindly adjourn the matter for the day, Lordship. My senior Miss Again is not well, Lordship.
Yes. Any objection? Why is it for orders?
Service upon the 3, 1 to 4 has been already completed. As regards the 5 private respondents, that is not completed. I don't think he is anymore in the service, or even if he is there, he is not in the particular place.
Respondent number 5.
5.
You furnish the details of respondent 5 to the petitioner so that steps can be taken. Counsel representing A. Gayan is permitted to obtain instructions with regard to the proper address of private respondent number 5, on whom service of notice although undertaken, the oh, sorry, you have been directed to take fresh steps.
We took the steps, but the address was furnished to us. It is by them, that man has already moved out that place. So
Why did you take steps?
we took the steps. There was a letter to us on 18th August stating that man has moved to MTN. Then we took the step on 2 MTN. I don't think he is anymore there in that place also, because it is almost 6-7 years past, and he may not be there in the service also. By the time he may be retired also. Even without him, the matter can be decided.
Then you file an application for striking his name off if you have no claims.
We like to, orally we like to.
Huh?
Orally we.
No oral. Why should we have an oral submission? You file application. You file an application.
Alternatively, we'll file letter.
As per office note dated 25/9/2025, steps on respondent number 5, fresh steps on respondent number 5 has not been undertaken. Para. Counsel for the petitioner, however, submits that steps were already taken. Stop. He further informs that perhaps the private respondent number 5 may have retired from service and has moved to some other place. Alternatively, he may be permitted to file an application for striking of the name of respondent five, as there is no specific claim against the respondent number five. You are not claiming against respondent five.
He was in the recruitment board. He was in the recruitment board
You have carried him by name.
by name.
Ah,
He was in the recruitment board.
are you now saying that you don't have any claim?
No, because in that, in the capacity of that lordship, we will not like to strike, we will not prefer striking order name. We will take against steps.
Second line to continue. The counsel for the petitioner is permitted 4 weeks' time to take fresh steps on the private respondent at the corrected address list accordingly.
11.
Right, my lordship. My lord, contempt case against the order dated 28/6/2019, my lord. You will also will find page number 27, my lord. Annexure D, my lord. Or 11% is page number 29, my lord. This court directed the respondents to examine the matter as per OM data 16/2015, my lord. If a vacancy is not available in the respective department, take the matter with any other department, my lord. And that exercise should be completed within a period of 3 months, my lord. Or DLC, my lord. But copy was served on August 5/8/2019, my lord. And thereafter, DLC was held in the year 2020, my lord.
Your Lordship, I was asked to produce some vacancy position regarding, this is the vacancy.
No, pursuant to this, was the order complied with?
No, my lord.
No, due to lack of vacancy, Your Lordship, he could not be entertained, Your Lordship.
At the
This
relevant
is the
point,
vacant position, Your Lordship. It is.
kindly please, your lordship order that 29/9/2013, my lord. There is a specific order by your lordship. 29/9/2013, my lord. 23, my lord. Lordship category observed that the order was not complied with, my lord.
This is vacancy position when?
It is there, Your Lordship.
As on August 25?
Yes. Yes,
But the order was passed in 2019.
yes, Your Lordship.
So vacancy position during that time is relevant.
Regarding that, Your Lordship, I have filed one additional affidavit there. I have mentioned the vacancy position
Where?
in page number 63, Your Lordship.
63. Yes.
Yes, the vacancy position, no vacant post, Your Lordship.
Lordship, kindly note that of page number 62, my lord. To start from 61 para 4, my lord, that the department best to state that the data showing available vacancies submitted by the department respective head of office under the district were reflected in the minutes of DLC meeting dated 4/10/18, 6/3/20 and 31st/12/21. But the DLC verified the same in the meeting and taken the decision as per existing norms of OM. It appears from the records available in the minutes that the petitioner so and so has applied for the post of grade 4 and such DLC can explore the available vacancy of the other department office within the district against the grade 4 post only, where there is no proposal from the concerned department. At that time, there is no proposal, my lord. On verification of all aspects, principal in government OM dated 1/6/15, my lord, the proposal of so and so could not be recommended by the DLC as yet. That was filed, my lord, in the year 2013, my lord. The affidavit was filed on 28 November 2023. As yet, in the DLC meeting 31st/12/21, the vacancy position was again reviewed, but due to non-available vacancy under the compensation quota in the respective office and other office in the district, the EEPWD Silchar Sonai, Dholai Territory Building Division, Silchar was requested to take suitable action as per clause 15 of government OM data so and so. Further, the vacancy position mentioned by the petitioner in relate to the year 2018-2020, that is 3-5 years old, my lord. At the time, there was sufficient vacancy, my lord. Recently, this office has served vacancy position under compensation quota from all heads of office, and accordingly, information of the following department were received so far, where the vacancy of grade 4 posts are found nil. However, the entire vacancy position will be ascertained on receipt of information from the remaining office, my lord. Entire, that the list is not for entire vacancy position, my lord.
For that, your lordship, I have produced today's instruction, your lordship.
An earlier read could pass a specific order to comply within period of 3 months or in pass in speaking order to that effect. But as on that, no speaking order was passed.
So there are some posts reflected here.
Those are regarding home department, your lordship, police constable, technician.
Huh?
Those are there, your lordship.
This is an.
Regarding he's applying for grade 4, your lordship.
Huh?
He is applying for grade 4, your lordship.
Grade 4, I'm talking about grade 4 only. You see the vacancy position under compassionate quota, grade 4?
Yes, your lordship.
You see serial number 4. There are 3 posts. Serial number 9, there is 1 post. Serial number 11, there are 7 posts. Serial number 12, there are 3 posts. Serial number 13, again 3 posts. Why don't you pursue it and fill it up?
Your lordship.
This is the vacancy position as on August.
In the
25.
remark column, your lordship, nothing is written, your lordship.
Huh?
In the remark column, your
So
lordship.
remark column, nothing is written means what? It is available.
Your lordship can, by giving a direction, your lordship.
What direction? Direction is already there. You call your district commissioner to court. We will ask him what is the meaning of this. Call him.
Your lordship, one date may be given.
No, but one date.
Your
He is given a instruction where all these posts are there and what direction he wants from the court. We are examining why the direction has not been complied with.
Your lordship, large chance may be given day after tomorrow, your lordship.
Third counsel for parties. This contempt petition is directed. against the respondents for willful disobedience of the directions contained in the order to which rainfall passed in the UP. Whereby the respondent authorities were directed to place before the concerned DLC for reconsideration the application of the petitioner for appointment under the scheme by examining the availability of vacancies in other departments as provided under para 15 of the OM, dated 1/6/2015. These exercise was directed to be completed within 3 months from the date of receipt of the certificate of the officer. Today, when the matter is called up, MSK Fupan, the junior government advocate, has placed before the court a communication dated 28th of November 2025, wherein the following vacancy positions were, wherein the following vacancy positions are reflected into chart 2, extract Porilum. This position, these instructions are submitted by the additional district commissioner, Kachar, Silchar. From the perusal of the vacancy position under compassionate appointment in different district level officers as on August 2025 is seen. Several vacancies are seen. However, it is not understood as to why the department, why the respondents have failed to comply with the directions contained in the order dated so and so, passed in WPC so and so. There are MS Fukan raised for a day's time to complete her instructions in the matter. Accordingly, list this matter again on 5th.
Yes, Your Lordship.
When do you want it? 5th.
5th, yes, Your Lordship.
He listed on 5th, enabling her to complete her instructions. It is made clear if specific instructions are sought for by the court is not placed before the court, then the consequential orders may be passed by the court.
Available.
Will kindly see order dated 28/25. Most on the last occasion, the petitioner council had placed that they will.
None appears for the petitioner on hold. None had appeared for the petitioner when the matter was called on 2008/2025. Mr. A. Fukan appears for GAD. Ms. U. Sharma for
3, 4, 5, and 6.
respondents 3, 4, 5, and 6. With petition dismissed for non-prosecution. Interim orders, if any, stand vacated, pending ayes are also dismissed.
Deeply appreciated.
13.
Lordship, item number 13, Lordship, we have complied with the order, Lordship. We have passed the speaking order. Petitioners have not been appearing in this matter.
This contempt petition is filed for willful disobedience of the directions contained in the order dated.
Lordship, page 10 of the contempt petition.
22/6/2022, passed in WPC 4098 of 2022. By the same order, the following directions were issued. Para number 7 for extract original. Mr. A. Cholia, learned counsel for the petitioner, has placed before the court that pursuant to the directions contained, the appeal of the petitioner to revoke his dismissal from service was reconsidered. So thereafter, the concerned authority, namely the Commissioner and Secretary, Commissioner and Secretary to the Government of Assam, Medical Education and Research Department, the concerned authority, upon considering the report and statements, found that the charges were framed and proved against the petitioner, and there is no merit in the statement of the petitioner. And the decision of the principal Chief Superintendent TMC and H Tezpur to dismiss the petitioner from service has been upheld. There are copy of this order by the notification number so-and-so dated 4/8/2023 has been placed before the court and is kept on record. Kept on record of considering the order passed on 4/8/2023, read with the directions contained in the order dated so-and-so passed into PCC so-and-so court is of the view that the directions have been duly complied with. Therefore, at this stage, the court does not wish to keep the concurrent petition any further. So, notwithstanding the absence of the counsel for the petition, contempt petition therefore stands closed, disposed of. Notices issued stand recalled.
Okay.
May, my lord, here the notice was issued upon the respondent number 4 and 5 through respondent number 2. In regard to respondent number 5, notice service upon the respondent number 5 has been completed. As per last
Lawazima court order.
What
my
about
lord.
4? Who's for 4?
My lord,
Respondent 4.
my lord.
Who is appearing for 4?
My lord, notice was issued to respondent number 4 and 5, my lord.
Ah.
Earlier it was respondent number 1, 2 and 3 was notice was issued, only 1, 2 and 3. Later on it was issued to
4
3
and 5.
4 and 5, my lord.
So
4 and
5
5 through
is
respondent number-
completed.
My lord,
4 is not complete.
my lord.
My lord, kindly have Lawazima order 18/8
8, my lord.
2005. In regard of respondent number 4, notice was served Lawazima order
18/8,
18,
yes.
8, my lord. Lawazima.
So confirmation on respondent 4 is not available. You take fresh step
My lord.
on respondent 5, respondent 4.
my lord.
Pursuant to the order dated 28/5/25, issuing notice to respondent 4 and 5, formal steps were taken by the petitioner. Stop. Lawazima court order dated 18/8/25 reflects that service on respondent 5 has been complete. However, service on respondent 4 is awaited. End of leave or not confirmed. So, under such circumstances, we permit the counsel for the petitioner to take fresh steps by registered post on respondent 4 within 2 weeks from today.
My lord, here respondent number 4, my lord, he may not be in that particular address.
I don't know.
My
The correct
lord.
address, you find out.
My lord.
Of like.
You find out the correct address and take steps within 2 weeks.
Obliged.
Matter be listed after 4 weeks.
Maybe the lawsuit. So in this case, I will file IA for implement of party of this lawsuit. Earlier, we could not file because due to lack of
You
communication.
want
with
to
the
file IA for implement of?
Party, respondent number 1 and 2 lawsuit. 1 is retired and 2 is transferred lawsuit.
You've been granted time, why have you not
Yes,
filed?
lawsuit, engaged counsel expired due to lack of communication with the client, we could not file lawsuit. They simply contacted the client. Tomorrow I will file.
You're Mr.
R.A. Ahmed.
Mr. R.A. Ahmed, learned counsel to the petitioner, pays leave for filing an application for implement of the respondent number,
1 and 2, as well as Mr.
implement for parties in place of the implement to how many respondents?
Respondent 3 lawsuit.
3.
As well as the history of lawsuit.
Implement of the incumbent who's presently which post?
Chief engineer lawsuit. Respondent
Chief
number 1.
engineer.
Yes, lawsuit. And superintending engineer. Respondent 2.
The present incumbents in the posts of chief engineer and superintending engineer, water resources department. Stop the praise for 2 weeks' time. Are you appearing for respondent 3?
Yes, is not.
Learned counsel, respondent 3 is represented by learned counsel. You filed your affidavits?
Is filed.
And the affidavits have also been filed. Well, let the matter be listed after 4 weeks, enabling. Let the matter be listed after 2 weeks, enabling the learned counsel for the petitioner to file implement petition as prayed for. List according.
Plus.
Application. Order dated 30/4/2025. Respondents were directed to file their affidavit in opposition as a last chance. As on date.
Who are the respondents?
A. Chakravarti for respondent number 1 and 2. There is no
Why is it for orders today?
for filing of affidavit.
Is there an IA?
IA, my lord,
Disposed
the
of?
subsequent development has been projected.
Disposed of?
No, no.
IA is pending.
Let it be along with the repetition.
Matter be listed for admission after 1 week. Mr. S. Sharma for the petitioner, none appears for the respondents. List again after a week. For admission.
Obliged.
May it please your lord. This is a contempt matter wherein your lordship, the direction with regard to the pension and the pensionary benefits have not been paid. Therefore, on the last occasion, a learned friend has submitted that it would be paid. One part of the, I think one part has been paid, that is leave encashment benefit has been paid. Rest of the amount have not been. Pension and gratuity have not been.
I'm appearing for respondent number 1, my lord. In the meantime, he had deleted this post, my lord. I don't have the latest instruction. Even then, my lord, I have the instruction dated 25/9/2025, my lord, wherein the full amount had that not been released to the GMC. Amount due is around 27 lakhs, out of which 27 crore, my lord. 8 crore has been received. Another 19 odd crores had to be received. At the moment this amount comes, my lord, from the Department of Housing and Welfare through Finance Department, this amount, pension will be released, my lord. This is the instruction.
Giving you legal advice, why do you file writ petitions?
No, we file the writ petition. And then after that writ petition, In the order in the writ petition itself, your lordship, there were two
You
parts.
said we are not giving you legal advice. We are only wondering why you're filing writ petition. This 19 odd crores is awaited. When is
19
it
odd
likely
crores
to
is
be
awaited.
received?
This is the letter dated 25/9, I don't have the further instruction, my lord. This was the letter written to
All these people who are praying for pension will keep waiting for indefinite period.
my
And
lord.
then their
But
legal
they
aid will
had-
run after the court.
They have received it, my lord, but some of this amount, full amount has not been there.
Only the leave encashment has been paid. That was paid.
Time has come for writ courts to invoke proceedings for attachment. Anyways, how much time do you require?
Well, the moment this amount comes out, it will work out because there are 583% that amount had to release. Though the working, that everything, amount has been worked out, my lord.
Vague. Moment it comes, when is it likely to
My
come?
lord, that's the difficulty, my lord.
What difficulty is this? These
Well,
people have worked, they
yes.
are waiting for pension. And the authorities are merely asking for half the amount is released, half is not released.
Yeah, but it had to be released.
Why
It
don't
had
you
to
sell
be
off your offices and give the returns to the?
It had to be routed from the department housing and that it had written there. Thereafter, it will go to the finance and the amount comes, my lord.
Yes, Mr. Manan, what do you say?
What can I say, your
You
lordship?
wait for
because
19 crores to come. As and when it comes.
That is the issue, your lordship. Nobody
Therefore, we
knows
ask
when it-
you why.
They are also not saying any specific date when it will be coming there.
Third counsel for parties, Mr. S. Bora, learned counsel for the petitioner.
And
has,
respondent one, my lord.
for the respondent one. Submits on instructions received. We are keeping this.
Lordship.
That amount of $27, $29, $85, $750 has been sanctioned.
This is demand, my lord.
Says FS was issued, financial sanction was issued.
Finance sanction, my lord, it is for 20, but what we had received, FOC, my lord, it is received for 8 crores.
So the sanction is for 27 crores.
Yes. But we have received 8 crore, my lord.
Against the GMC employees' pension. Stop, however, fixation of credit was released amounting to rupees 8 crores. The balance. The demand for the demand for fixation of ceiling for the balance 19 crores 19, 85,750 is yet to be placed. So he submits that once this amount, once the FOC for the balance amount is issued, then the entire amount can be released towards pension of GMC employees, including that of the petitioner. Some amount you have received.
That is the leave encashment, about round
Out
about.
of these 8 crores, how much amount is he entitled to receive? Some amount has been received.
But some amount has been, ultimately have to finalize everything, my lord, and then release it, my lord. That finalize everything, calculation has already been done. We will get that particular amount from the monthly
So out of
monthly.
these 8 crores, proportionate amount, something has to be released. Or
Well,
you're not
that-
releasing.
That instruction I don't have it, my lord.
The standing council will place before the court whether any proportionate amount from the amount of rupees 8 crores which have been received by the GMC will be released to the petitioner. Let these instructions be placed again before the court, along with the status of the FOC for the balance amount be placed before the court on 9th of January.
No.
2026.
Obliged.
Obliged.
Item 19.
May Lordship, my lord, here, notice was issued upon respondent number 6 to 9.
But there is
And
confusion,
respondent-
but, the affidavit has been filed by the central government council, my lord, for the officer respondent, my lord. But in the affidavit, it says, my lord, it was filed all the respondent, my lord. Actually, it was filed for only for the, my lord, officer respondent, my lord. In the representation, there is, my lord, also private respondent is there, my lord. So when the Lozima court, my lord, observed that the affidavit has been filed all the respondent, my lord. You file an application seeking correction. Yes, madam. You have to file an application seeking correction of this order. Yes. As also an application that you may be allowed to correct it. Yes, sir. The affidavit. Yes. Yes, sir. The respondents in the matter have, the official respondent in the matter has filed an affidavit on 27th of September 2023. In the post title of the affidavit, it is specified that the affidavit has been filed on behalf of all the respondents. In the present writ petition being WPC 14858, there are five official respondents and 4 respondents who are arrayed as, who 4 private respondents who are arrayed by name. Stop. The learned CGC submits that by oversight, the affidavit was filed by the official respondents. Right, the CGC submits that although the affidavit has been filed by the official respondents, by oversight, it was stated that it is filed on behalf of all respondents. Stop. And as a consequence, the Lozima Court, by order dated 11/8/2025, recorded that since the affidavit has been filed on behalf of all the respondents, the service in respect of respondents 6, 7, 8, and 9 are complete, and matter be posted before the court. So the learned CGC therefore submits that he be permitted to take necessary steps for correction of the same by filing appropriate applications, raised for 3 weeks' time, where made is allowed, list after 3 weeks.
Wrongly listed order column.
Huh?
But it is wrongly listed before the order
Wrongly
column.
listed.
But
Right.
matter pertains to some amount recovered from the retirement benefit after retirement.
No, you are saying wrongly listed before this code or orders?
Orders, my lord.
Orders.
Order column.
It should come for
Admission, my lord.
admission. Mr. K.R. Patgiri for the petitioner, Ms. S. Sharma for help,
Health respondent 1, 4, and 6.
respondent 1, 4, and 6. Okay.
Lordship, I'm M. Das, appearing on behalf of SK Medi for respondent number 5.
M. Das for respondent number 5.
I appear for respondent number 2.
Mr. A. D. Bora for respondent number 2. Counsel at the bar submits that notice having been issued in the matter. Rule has been issued.
My lord.
In the matter. On 15/9/2023, the matter should be listed for hearing. Affidavits exchanged.
No, my lord, only respondent number 5 filed.
Have to be listed
We are
for
supporting. We are supporting that affidavit.
hearing in the month of February.
Obliged.
2026.
Lord, in this case, my lord, connected retail pending before the division bench, my lord. Retail number 28723 and to be listed on my lord 11/12, my lord.
It is submitted that against the order passed by the coordinate bench in WPC number
WPC number,
1646.
my lord,
So this is that 3 years.
3 years, my lord.
1646 of 2021 and other connected matters. And against the judgment and order dated 3001/2023. Writ appeal has been preferred by the respondent state. When the matter is still pending before the
Division bench.
the division bench. The matter therefore be listed again after 8 weeks. Council will, for the parties, will apprise the court in the event the writ appeal is disposed of.
Well, I'm appearing for respondent number 2 and 3, man.
Mr. A.S. Doctor for respondent 2 and 3.
Hello.
23.
May I please, your lordship? Lordship, we have already complied with the order.
Complied.
Yes, speaking of.
The grievance of the petition, yes.
Lordship, in this matter, we have filed one additional affidavit, Lordship. So most probably it is not there in the file, Lordship. So can it be taken up on Friday, Lordship?
Have you seen the order passed by the respondent?
Yes, Lordship. I don't have.
Have you seen this order?
I have received it just now, Lordship. I have seen it, but that additional affidavit is required, Lordship. in
All
this
right, it
matter.
will be on Monday, 8th. It is submitted by the counsel for the petitioner that An additional affidavit is filed by the petitioners, which however is not available on record. Mr.
C. Paul.
C. Paul, learned counsel appearing for the APDCL on the other end, submits that the directions contained in the order dated so-and-so, passed in WPC so-and-so, has been complied with, and therefore the contempt petition may be closed. He has placed before the court a speaking order dated 15/10/2025, whereby the authorities rejected the contention of the prayers of the petitioners for enhanced remuneration. The said speaking order dated 15/10/25 is placed on record. It is kept in the case record. Placed on 8th.
Much obliged.
Much obliged.
24. Yes.
My lord, the petitioners were appointed as daily wage labor. And they have already continued
There are orders on it.
almost 4 years of service, my lord.
Why is it come for orders?
My lord,
Why is it listed for orders?
Yes,
Some
my lord.
affidavit was to be filed.
Lordship, perhaps the affidavit in reply is not like in this petition. perhaps,
we have filed this.
Not in the report. That's why perhaps it is in.
Affidavit
order
in
for-
reply, have you filed or you?
Yes, my lord, filed.
You have filed?
Yes.
When did you file it? When was it filed?
It was filed on 25th, 11/25.
It is not available on record. So we'll list it for admission.
Yes, ma'am.
As per office note dated 17/10/25, the affidavit in reply permitted to be filed by the petitioner has not been filed. Para Mr. C. Decca, learned counsel for the petitioner, on the other hand, submits that the affidavit in reply has been filed, which however is not connected to the case record. Stop registry to trace out the affidavit in reply stated to have been filed and list this matter for admission in the month of January.
My lord, the interim order may pending, my lord, to
Interim
continue.
order passed earlier will continue.
Obliged.
And the second photocopy for veterinary.
For
Veterinary.
animal husbandry and veterinary.
Veterinary department, animal husbandry and veterinary, Mr. C.K. Borwa for respondent number 1. Yes.
May I have listened? As per Lojima order, service is complete in respect of all the testimony.
এর কোনো করানো নেই, কোনো তো নাম show করানো নেই।
As per Lozima order dated 19/11/25, service on respondent 6 to 40 has been completed. As per the postal track consignment reports generated, which shows that notice in respect of respondents 6 to 40 has been delivered on 13/8/25. So, Mr. Parahor appears for respondents 1 to
1 to 5, my lord.
1 to 5.
Maybe list for admission, my lord. In the meantime, I'll file affidavit, my lord. I have just received.
Accordingly, let the matter be listed for admission in the month of January on a date to be fixed by the registry. And the respondents are permitted to file their affidavits in the meantime. List accordingly.
Dear Lordship,
Lordship, the service upon respondent number 427 is not completed due to change of their address, my lord. So I may be allowed to take fresh steps on the
Counsel for the petitioner is permitted to take fresh steps on respondent 427
427.
on the correct address within 1 week from today by registered post. Let the matter be therefore listed after 4 weeks. Mr. Odhikari, learner CGC, appears for respondent
1, 2, 3. Okay, deep level.
22nd.
On the last occasion, the respondents to file affidavit in this matter.
Hmm?
That has not been filed also.
What?
On the last occasion, affidavit was required to be filed, but that has not been filed till date also. It's order dated 28/2025.
Service on respondent 3 is still awaited.
Respondent number 3. I think on the last occasion, as Chutia appeared lordship. Respondent 1, 2, 3 lordship. And for 4, MSRM Borua appears.
S. Sutia and RM Borua. We'll call it up after a while.
Lordship.
Call it up after a while. Flash political note.
My lord, here, direction was to revise the pension and pensionary benefit of petitioner in terms of national benefit. During the pendency of this contempt, error amount of pensionary benefit has been received. However, my monthly pension has not been revised.
Your pension?
Monthly pension has not been revised. And in terms of notice, neither ethical and nor answered notice has been received.
Matter be listed after 3 weeks. And as the office note, matter be listed after 1 week. And the registry will make necessary endorsements as to whether service on the respondents have been completed after a week.
Offline.
On office note dated 27/11/2025, indicates that neither ID card nor answer notices have been received, my lord. If I may permitted to take
Yes.
Dusty,
You want to take fresh steps?
Dusty, my lord, Dusty preferable.
Dusty.
Yes, ma'am.
As per office note dated 27/11/25, ID card awaited. Sorry, service on respondents 1 and 2 are awaited.
My lord.
So counsel for petitioner, Mr. M. Sharma, claims leave of the court to undertake fresh steps by Dusty.
My lord.
That's all. Accordingly, Dusty is permitted to be routed through the registry of the court. And thereafter an affidavit of compliance be filed. Matter be listed after 4 weeks.
My lord, I'm grateful.
Maybe lordship, my lord. My lord, whatever your lordship order, my lord, is 34 months.
ID card awaited on
My
respondent
lord.
1 and 2.
Yes, my lord, that is right, my lord. I have seen the order sheet. But Deputy Commissioner Nagav and all of the,
Take fresh steps or Dusty?
whether Dusty they accept or not, it is the problem, my lord.
You take fresh steps then. Office note dated 31/10/25 reflects service on respondent number 1 and 2 are awaited. All right, we direct the registry to verify and give a report.
Yes, my lord.
Matter be listed after 2 weeks, after 3 weeks, by which time the registry will inquire and give necessary and make necessary note with regard to the service of notice on respondent 1 and 2. That's the problem. 33. None appears for the petitioner on call. Yes?
I'm appearing for respondent number 2,
MSRR
Kakoti.
Kakoti appears for respondent 2. Mr. B. Deka for
Respondent number 3.
respondent 3. So,
Lordship, copy of writ petition has not been served upon us, Lordship, till today.
none of you have received.
Well,
Yes.
I have received, my lord.
I have not received.
Counsel for respondent 2 submits that copy of the writ petition as a not
Extra to now.
on 4/8/25, when the matter was called, none represented the writ petition. Accordingly, matter be listed after 1 week. None represents the writ petitioner today, and the matter is called, is after a week.
Before.
Service is complete, my lord. As per lodging mark order, my lord, 26/11.
Private respondent.
What is this IA for?
For implement of parties, my lord. Notice were served.
Pursuant to order dated in the IA, pursuant to order dated 6/8/25, notices were issued of the party 1 to 26. Upon steps been taken, it is seen from the office note dated 26/11/2025 that registry has the office note reflects that service report on respondent 1 to 26 is complete. Any objection?
My lord, I appear for the opposite parties 1 to 26, my lord. I will be filing my wakalat number in the IA, my lord.
Mr. PK, PR Sharma
Yes,
appears for
file it
the
today, ma'am.
respondents 1 to 26 who submits that he would like to file the wakalatnama. You are also filing an objection.
my lord, I'll get instructions today. Today I'm only filing wakalat.
MS D. Bora for
Health Department. Lordship.
Department of Health.
I am appearing for comment 3 to 9. Writ petition.
MS so and so appears for respondents 3 to 9 in the writ petition. With respondents 3 to 9. The parties are permitted to complete their instructions in the matter. What about the IA? What about any objections in the IA?
My lord, I will seek instructions and as to the city.
Parties are permitted to complete their instructions in the IA. The matter be listed again after 2 weeks.
Yes, my lord.
After 2 weeks.
Give you. 25.
Yeah, what is the IA for?
What's it, the copy of the IA, not yet served upon mail, sir.
Huh?
Copy of the IA, not yet served upon mail, sir.
Not
Last
yet
occasion-
served upon you.
Last occasion also
None
they,
appears
none
to the
appears.
petitioner.
I for implement.
opposite party number 6.
None appears for the applicants. The IA.
Last occasion,
Last
last
occasion.
None had appeared for the applicant when the matter was last put upon 26/9/2025. So Mr. N.J. Gugoi appears for respondent 4.
4 and 5.
I am for respondent number 3, your lord. Arboro.
Arboro appears for respondent 3. And Mr. C.K.S. Borua for
Respondent number 2.
respondent 2. For ends of justice, matter be listed again next week.
Bless.
Applicant is item 41.
Well, in this matter, my lord, my affidavit was ready. I served copy to him. He filed his rejoinder also, my lord. But somehow, my lord, I didn't file the affidavit. So, my lord, I'll
You
file
did
it
not
tomorrow.
file the evidence.
Yes, my lord. Everything was ready. It was notarized
File the
also.
rejoinder.
My lord.
After receiving the,
When do you want to file it?
Tomorrow, by tomorrow. Everything is ready, my lord. It's notarized also.
Huh?
On 4th of September, it was notarized.
Without any changes?
without any,
Changes, I think, well, it's not, it will not be required. So, Lordship may kindly fix the matter next week, my lord. So let me see.
We are
the-
not inviting you to put in
My lord, my lord.
changes, considering the fact that he has also filed a reply.
Yes, my lord. So, well, I'll have to file this only. By tomorrow, I'll file.
All right.
Yes.
It will be listed next week as it is submitted by the counsel for the petitioner, for the respondent, that the affidavit in opposition could not be filed. Although copies were served to the counsel for the petitioner, to which the
Reply
counsel for
also
the
filed.
petitioner has filed a reply affidavit. Let this matter be listed next week, enabling the learned CGC to file the affidavit. During the
item
course
number
of the week.
44, my lord.
Huh?
Same matter, item number 44, my lord. Same
44
parties,
also
my lord.
not filed.
My lord, in that case, my lord, it is already complete.
44 you have filed.
Filed, my lord.
Who's, there some other council appears.
Other than UK.
Let the other council be there.
42.
Matter pertains to the promotion, consideration of the promotion of the petitioner to the post of DCF, my lord. The affidavit, despite direction of the last day, no affidavit has been come with me.
Yes.
My lord, there is a connected writ petition today listed at the coordinate bench, my lord. In that connected writ petition, they have submitted two representations. That, my lord, the department will consider, my lord,
That
may,
is in respect of the debtors of
That is in some other writ petition, not here.
because that will have a bearing here also, my lord, in this case, so.
Where is that, when the writ petition is listed today?
Today, my lord.
Today,
Right. It is submitted before the courts by the counsel for the respondent that another writ petition filed by the petitioner is
this
listed.
is so
in
far
the
respect to
coordinate
the
bench.
post of SCF, your lordship.
Huh?
That writ petition related to the providing promotion of the retrospective effect of the SCF, your lordship. This is connected to the DCF, your lordship. There's no relevancy with the present petition. That in this case, your lordship.
Which is the higher post?
Higher is the
This
DCF, man.
DCF.
Yes, lordship.
So this will have relevancy with that because
ma'am.
unless your promotion effective date in ACF is fixed, It will have an effect on this. How do you say it is not connected?
No, because we are, whether in this case, Your Lordship, the junior men who are being promoted in the year 2024. And this case, already petitioner was promoted to the post of ACF, my lord.
Have you filed your instructions here?
No, Lord.
No. What you have a representation here? No.
Not here, Your Lordship.
Why has it not been considered?
That, my lord, our instructions are awaited, my lord. That is why I prayed, my lord, that may be disposed of by asking the authorities to consider his case, my lord.
On
Yes.
such vague things we don't dispose of. You find out, you tell us why his promotions are not considered.
Then I may be given a week's time. I'll
List this matter on 10th, enabling the respondent counsel to complete his instructions as to why the case of the petitioner for promotion to the higher post of DCF. DCF, which is Deputy Conservator of Forest, has not been considered, although persons junior to him in the gradation list have been considered. But let these instructions be placed before the court again on 10th of December.
43.
Here, Your Lordship, I appear on behalf of Mr. Deenat. We would like to say, file an affidavit in this matter. So we seek 2 weeks' time to file affidavit. The other bunch of connected matters in this writ petition otherwise.
Your Lordship had passed a detailed order on 28-25.
Yes,
Your Lordship had passed a detailed order on 28-25.
yes. MSB Chaudhary appears for the petitioner. Mr. D. Bora appears for the respondent, who submits that further time be granted to complete his instructions and file necessary affidavit. Matter therefore be listed after 4 weeks.
Interim to continue.
Matter therefore be listed after 6 weeks. List again on 28th of January. Interim order passed earlier will continue.
This case, my lord, it is already complete, my lord. I also filed a affidavit, my lord.
Yes, Mr. Rodigari.
I'm appearing on behalf of Mr. UK Goswami, man. UK Goswami is in the case.
Take along with that matter, my lord, item 41, my lord, the same issue, my lord.
Is he available in court today?
I haven't seen him today.
Alright, it is submitted that this matter be listed along with
Allowed, my lord,
petition number
application number 23/25.
23/25. When is that matter fixed?
No, that date has not fixed, my lord, after weeks.
Next week. Next week.
All right.
45.
My lord, I have gone through the case laws provided by the petitioner, my lord. Not a single case is covered in this case, not applicable in this case, my lord. Because I have seen, my lord, all the thing, I have given the gist of this, my lord, all the cases, my lord, we have written it. All are, these are apparently, my lord, they are before 2005. They were in the service, but the petitioner is in 2006. 2006. The court's order.
No. His case is that it was, it may be a fresh appointment, but his services earlier cannot be wiped out. This is one. The other is that even if it is considered to be a fresh appointment, he is still entitled to the benefits after having rendered more than 10 years of service after the fresh appointment.
No, my lord, I have seen the case laws, my lord. They are not like that, my lord. They are computing his period of service and taking into the initial appointment.
No, now is he entitled to pension or not?
No, he is entitled as a my lord pension as per new scheme. My lordship kindly see, I have gone through it. my
You
lord,
are
I-
agreeable to that? On the last date, you are agreeable?
Yes.
My lord, but new defined pension scheme, no contribution has been deducted. I will be governed under the old pension scheme only, although there is they have admitted that under the new defined scheme, but since they were contractual employees, my lord, subsequently they were regularized. So under the new defined pension scheme, contributions has to be deducted from the salary. That has not been done in any of the case, my lord. The border employees in the entire state of Assam. They are governed under the rule 108 proportionate pension, my lord, more than 10 years of service. They all are granted pension. So here, my lord, I have completed 13 years of service. Even
How is he going to be governed under the new pension if
there is no contribution.
Yes, my
is
lord.
not deducted?
So far, my lord, this provision is there, my lord. Lordship kindly see the Assam Service Pension Manual, my lord, page 314.
Pension.
Yeah, two tier thing is there. That's a quote. Just to quote. Guidelines for implementation of the new defined contribution pension scheme. Actually, he used to deposit the amount and the same amount would be deposited by the government, CPF. And he used to, at a retirement ballot, 40% he can, he will have to keep the 40% in
What
his account.
happens if he did not, if his contribution was not deducted? What happens?
That is the, not deducted, he will, two option is there, Tier 1, government servant will have to make a contribution of 10% of his year basic pay, DNS pay, if any. DNS allowances plus non-practicing allowance which will be deducted from his salary, bill every month for the drawing and disbursing officer while calculating 10% of basic pay.
You are reading from?
I am reading from guidelines for implementation of new defined serial number 10.
Where does one get a copy of that?
That
Give us a copy.
It is there. Well, highlighted all these things, rule 6. Guidance আছে না? No.
Yes, guidelines.
Yes, guidelines, also 6. 6. The Assam Service Pension Rule 1969 and amendment made from time to time thereon will not be applicable to government servants who join on or after 1st February 2025. Apparently, ballot, his case has been assumed ballot, his fresh appointment is 2006. And 10. In a Tier 1, government servant will have to make a contribution of 10% of his or her basic pay, DNS pay, if any, so allowances which will be deducted from his salary bill every month by the drawing and disbursing officer. While calculating 10% of basic pay, DNS pay, DNS allowances and non-practicing allowances, etc., the fraction of a rupee to an amount of rupees 0.50 paisa and above may be refund of to the nearest rupee. Fraction of 0.5 to the government in turn will make equal matching contribution to Tier 1 through the Director of Accounts and Treasuries, Assam from grant 13 out of the provision of the under 2071 pension and other retirement benefits 117 government contribution for new defined contribution pension scheme after issue of necessary sanction. 11. The contribution towards Tier 1 cannot be withdrawn till the date of superannuation and the date of leaving the scheme before attaining the age of superannuation.
When you read after that, next.
Oh, yes. The contribution towards new defined contribution pension scheme in respect of such employees shall be recovered from the salary through pay bills.
So you are supposed to recover it. Have you recovered?
I don't know, my lord.
If you don't know, then
The petitioner, he can know, my lord, whether he is drawn or not.
report will be available with you.
No contributions has been
The
deducted.
contribution towards new
The
defined
employer-
contribution pension scheme in respect of such employees shall be recovered from the salary through pay bills. In case of government servants who were under suspension or during subsidy allowance, the contribution may be recovered from the subsidy in case of which half pay. Right, and my lord, next page, my lord, 24. Area contribution towards the new defined contribution pension scheme of the employees who join on or after 1/2/2005 will, however, be optional as defined below. The employee may contribute their due area, my lord. Employee may contribute their due area contribution towards the above scheme at the time of government will pay similar matching contribution of the employees. If they desire, then government will pay. Employees who opt to contribute their due area contribution with effect from the following month of their date of joining may contribute their area contribution in installment basis. Government will provide similar matching area contribution so contributed in the installment. These are the provisions for the guidelines. So where the petitioner, whether preferred or not, my lord, it is up to him. So, apparently, my lord, I have one case law, my lord. My lordship kindly go through it, my lord. I have a case law. I did it with it. Lordship, I am sorry, I rely on the case, my lord. Yes, this is there, my lord. This is the case, my lord. In this case, what happened, my lord? My lord, my G's lordship kindly see it. I have written all these things.
Yes.
2/7/1963, the respondent, it's a appeal by the state government. But in the High Court, my lord, single bench and division bench are felt that he should get the pension or his grave period would be counted for period for the payment of pension. That is the case. State government made an appeal before the Supreme Court. Fact is there, but 2/7/1963, respondent was appointed as a lecturer botany in school, higher secondary school. And 1965, respondent applied for the post of lecturer degree college pursuant to advertisement, was selected for the said post. Because he 2/7/1963, respondent, he was working appointment in the school as a lecturer. And one post was advertised in the degree college, 1965, he applied and he selected. And 65, respondent resigned from the aforesaid post lecturer botany, enable him to join in the service. Accordingly, he joined in 3 January 1966 in the new post of lecturer, and he absorbed there permanently. And 31st May 2004, retired due to superannuation. While the respondent submitted pension paper claiming completion of period his past service for pension 2/7/1962 to 2/1/1966. That is, he was working in the school in a botany lecture from 63 to 2063 for qualifying his service for fixing the pension. His claim was there. And paragraph 11, the state respondent contended that the respondent had voluntarily resigned from earlier service to join new post of lecturer in degree college. And his resignation is accepted by the state, so he is not entitled to claim any benefit of earlier service for counting qualifying service for fixing the pension. Paragraph 12, Read code by order dated 5/7/2013 allowed a writ petition for calculation of the qualifying service of the counting the pension from 2/7/62 to 3/1/66. And division bench upheld the order of the single bench. Then hence this followed writ appeal. Paragraph 17. In our considered opinion, the respondent was not entitled to claim his benefit of his past service benefit, which he rendered from 2/7/1963 to 2/1/1966 as lecturer in government school while determining his qualifying service for fixing his pension, etc. Paragraph 19, my lordship, kindly see. In our considered opinion, the effect of tendering resignation from the respondent may be for any reason was that the relationship between the parties insofar as that particular employment was concerned got severed for all purposes, leaving no benefit to remain in the respondent's favor. It had no connections with the respondent's subsequent employment which began from 3166 degree college. It is tried law that the right to claim pension is governed by the statute. An employee has therefore no right to claim any benefit in relation to pension due the statute. And next ballot, so Supreme Court rejected it. No, he will be entitled because his relation, when he was supposed, he was not freshly appointed ballot. He was discharged from service in
Pay him under the new pension rules.
Oh, a new pension rule, he will be applicable.
You pay him.
Oh, the Lordship can, he will be, he will get it. I am not saying, but he not will get the proportional pension. Proportional pension only old pension.
You pay
Not
him.
other. I have seen in the case laws, all these things, he referred it. All petitioners are joined before 2005, 93, 56, like that. And it is not covered. And my this case, why I am relying this case, my lord, is says, my lord, when he resigned or he discharged from service, he has no relation. So Supreme Court says, no, past service cannot come.
You pay him.
Yes, but as per new pension rule, my lord, he will be entitled.
Again, my lord,
But he is not
He is agreeable to receive pension under the new pension rule.
New pension rule.
but my lord, subject, if the deductions are not made, again, the order would not be implemented.
You don't know, they say it is applicable.
It is not made. My lord, actually, my lord, the payment is made under Rule 108. If I may rely on the judgment, my lord, which I have earlier given, WPC 1147 of 2013.
No, what is the situation on facts?
Situation on facts is, my lord, that admittedly, my lord, no contributions have been deducted.
Your claim
nor, my
for
lord, the
pensionary benefits.
Yes, my lord.
Since your date of initial appointment.
My lord.
Cannot be accepted in view of the interpretation given by the court.
Yes, in that case, my lord, even then, my lord, my subsequent period, I am
Subsequent
having
period, you are
13 years,
entitled,
9 months
they will
service.
examine and make necessary payments.
Yes, and that has to be, my lord, my humble submission, my lord, is that should be made as per Rule 108 of the, my lord, Assam pension rules in terms of the division bench judgment of this court, my lord.
108.
Yes, my lord.
Yes. Yes.
Rule 108. Calculations, my lord, on the basis of the salary, my lord, 108B.
This is as per the old pension scheme.
Yes, that has been affirmed, my lord, by the division bench of judgment. Similar, my lord, employees, the WPC, my lord, 1147. I have given, my lord, earlier the copy. There are series of writ petitions, my lord, several employees approached, my lord. WPC 1147 of 2013.
I have
What
gone
is the
through
name
it.
of the party?
My lord, I have just printed out the, from the website of the High Court, my lord, the citation would not be there. It is there, and name of the
Division
party,
bench. Rate appeal.
WPC 1147 of.
1147.
Yes.
That was before.
My lord, page 6.
नाम तो केस ले पार्टी नाम
Page 5 onwards, my lord, if I may read, my lord.
You read the whole judgment?
Yes. Heard Mr. D. Chaudhary and Dr. M.L. Gupta, learned counsel for the petitioner, also heard V. Bechkar, learned counsel for the Accountant General's Office, Mr. M. Bhagawati, learned government advocate, Mr. A. Chetri, learned counsel for the Pension and Public Grievances Department, and Mrs. A. Verma, learned counsel for the Finance Department. All the writ petitions are being disposed of by a common order, as the fact situation is similar in all the cases. The only difference in the facts is with regard to the number of years of service of the petitioners. The petitioners in all the cases have worked as employees in the border organization of Assam Police as per the Prevention of Infiltration of Foreigners scheme. The petitioners in all the cases, including the husband of the petitioner in WBC 1124 of 13, have worked for more than 10 years but less than 20 years in the said organization under the PIF scheme. The petitioner's case is that after the retirement from defense service, they were selected for being appointed in the border organization of Assam Police under PIF scheme. The particulars of each of the petitioners are reflected below. Lord, I am skipping that part, my lord, then coming to the next page. The case of the petitioners is that after retirement, they had applied for pension as per the rules. However, they had not completed the mandatory period of 20 years of service. They were denied pension by the respondents. In WPC 1124 of 13, the petitioner is the wife of the person who had served in the border organization of Assam Police, and she has prayed that besides the pension payable as per law, she should also be given the family pension. The Government of India has formulated the Prevention of Infiltration of Foreigners scheme for Assam for strengthening the Assam governmental machinery for detection and deportation of foreigners in the year 1960. This scheme was extended from time to time. In the year 1987, the Government of India created additional scheme for the existing PIF scheme. It was under this PIF scheme that the petitioners had been recruited. While some of the petitioners were recruited in the time scale of pay, the others were recruited in a fixed pay. The Inspector General of Police Border Assam issued a circular dated 17/3/95 laying down procedures for appointment continuation of ex-servicemen in the additional PIF scheme, whereby conditions for yearly renewable contracts of service to the staff of additional PIF scheme had been imposed. This circular dated 17/3/95 was challenged by way of two writ petitions before this court, and a single bench of this court had allowed the writ petitions, clarifying that there should not be any break in service of the persons recruited into the scheme, and they would continue as long as the scheme was in existence. The single bench also observed that the persons recruited under the additional PIF scheme shall be entitled to all service benefits as regular employees so long as the scheme continues. It was also held that the benefits extended to the ex-service personnel in the Assam Special Peacekeeping Force wide office memorandum dated 14/6/84 shall also be applied to the persons recruited under the additional PIF scheme.
Any further appeal against this judgment?
No, my lord.
So these judgments received the petitioner when the petitioner joined before 2005, and they joined before they were working for 70 to 18 years, and they were appointed 93, 94 like that. And they covered by the old scheme, by law. Old pension rules, not new pension rules. And break-in service person recruited in, but there is a break, because the pronouncement of the judicial ballot court has said that he is a fresh appointment. So it is a break. It is not an artificial break. So here is said it should not be a break. Yes, in PIF, those who are working, they should be continuing. That is
Therefore, 108.
108.
Because they were all appointed well prior to the new pension code, and they had put in 10 years or more.
Yes. Lord, here, Lord, one fact, if I may like to humbly submit, my lord, when the petitioner was reinstated in service, the nature of service was still contractual. It was subsequently, my lord, all the border employees, my lord, under the Assam Police, their services were regularized, my lord, with effect from the date of joining. All were given, my lord, time scale of pay. Earlier, my lord, they were getting fixed scale of pay.
Where is that order?
The order is, my lord, the order passed by the governor, my lord, 23/9/2011.
all of these earlier, all are before 2005 appointment. But they retired before 2005.
No, that order is at page 27.
Petition.
Page 27. Petition. My lord, in paragraph 1, my lord, have been stated, in terms of the judgment passed by the Honorable Supreme Court of India, the ex-servicemen recruited against PIF scheme are to be treated as regular employees with effect from their date of joining, as per the MHA letter dated.
Where is that letter?
25/2/2011. That is here, my lord. I am here.
all employee will get the scale of pay. He was also given the scale of pay.
My lord,
It is
his
not a
services
issue.
were regularized subsequently. So his date of, my lord, because when the rejection order, my lord, clearly says my services were contractual in nature. Whereas it was not so. When I was reinstated, my lord, my services were regularized with effect from my date of joining. Therefore, my lord, I am on the counting of the earlier period, the
No,
subsequent.
but in your own invitation, you've got an order of the court saying that this is a fresh appointment.
That aspect was not brought before the court, the regularization, my lord.
They
When
should
I
not
was,
file a review. Why are you wasting time here?
that was not the subject matter. That is what my lord, I am humbly submitting, my lord.
No, that may not be
Only
the
the
subject
period
matter,
of.
but this is a finding of a coordinate bench. If you are
Ah.
aggrieved, then you have your remedy is not by filing a separate writ petition. It has
Hmm.
to be by filing a review or an appeal.
Yes.
No, in that case, subsequent period will be there, my lord. The subsequent period I am entitled under 108. The earlier period is only 2 years, my lord.
How it is applicable? It is
That, my
for only
lord,
for all
even if
pension
it is
rolls.
not counted, my lord, the subsequent period may be
He
counted
was
under
appointed after
108, my lord,
2005.
in terms of the judgment, my lord.
No, but then you go and file an application before the authorities that you are entitled to this.
Yes.
pension.
If
They
it
will
is
work it
applicable.
out.
My lord, it is, my lord, they have stopped my pension, my lord, without informing. That is another aspect, my lord. If I was entitled under, my lord, different rule, they ought to not to have stopped it, my lord. They should have given me the reason first. Initially, they processed the pension, my lord, taking my entire service, even the break-in service was taken into account. That may be the error, my lord, that they can correct it now. And
Where is the impugned order again?
is 67, my lord. The impugned order, my lord, reflects still that I am in contractual service, whereas that is not the fact, my lord. My services are being regularized now.
Yes, the regular as well, from 29/6/2006.
On one hand, my lord, there is a submission that for the subsequent period, I am entitled under the redefined scheme 2009, whereas the authorities have arbitrarily, my lord, stopped my pension. Although initially they granted, my lord, even issued the PPO order.
This pension, provisional pension was calculated on the basis that you will be entitled to pension under the old rules.
Yes.
But subsequent to the,
No, my lord, subsequently they have finalized the PPOs.
they have, but
Yes.
then in view of the order passed by the court in a writ petition
Yes,
filed
my
by
lord.
you,
Yes.
they treated it to be a
Yes,
fresh
that
appointment.
will disentitle me for those 3 years, my lord, which they have wrongly calculated as continuous service.
Hmm.
That will disentitle me, my lord, that they can correct that error and recalculate the pension, my lord, as per rule 108.
No. Because so long the fresh appointment observation is there, your appointment has to be counted from the date you
Yes.
are appointed.
Even if it is counted from that date, my lord, my service is 13
That
years.
108 is not applicable to new pension rules.
108, my lord, will be applicable, my lord, as per the judgment which I have given, my lord, because admittedly,
No,
my
as
lord,
per your judgment, because the judgment was rendered in respect of personnel who were already in service well prior to 2005.
Lord, here if I may humbly submit, my lord, I was also employed, my date of joining.
You're moving around in circle
My
in
lord.
the same issue.
My lord,
We have understood your case
Yes.
that you have joined prior.
my lord.
You want your pension, provisional pension was there. Then you came before the court rendered a judgment saying that this is a fresh appointment. You sat over it, doing nothing. Now you want an interpretation from another coordinate bench that no, in view of other orders and judgments of the Supreme Court, this has to be read down and continuous service is to be
No,
given. We are not
past service,
exercising
my lord.
appellate jurisdiction.
Past service I am not submitting, my lord, only the subsequent
So
period.
how do we know that you are not submitting? You file a proper application before the court or you go and file a representation before the authorities.
No, my lord, my subsequent services may be
No,
under
not like that,
108,
not
my
like
lord.
that, not like that, Mr. Gupta.
Because, my lord, admittedly, my lord, I can make a statement on oath. No contribution has been deducted.
Whatever it may be.
My lord, in that
you
case,
are-
my lord
if you are
will
agreeable-
ask them to bring an instruction.
If you are
Whether under
agreeable,
the
why
new defined scheme, they
if
have
you are
deducted, my lord.
No, then why are you submitting that your fresh services are to be considered? Fresh services will be considered under what provision?
Under 108, my lord, if
How
they
are
have,
you entitled to the old pension rules in view of this finding? To bring on record that you are agreeable for consideration of your case for pension under the new pension rule.
I'll take that.
You file your application.
Yes.
How much time do you require?
My lord, in that case, my lord will allow under the new defined pension scheme. I have
No, not like that. Why
No.
should we allow you?
My lord.
We want your specific submissions before the court on record.
No, I can do that, my lord.
Yes, do it by Friday.
Can do that. But
Least
subject
on
to, my lord,
Friday.
if no deductions are made, my lord, then again, the order will.
We don't know what.
That is the.
We will consider these
that's
matters
what
only on the basis of your submissions. You have threefold submissions, all overlapping the other.
No, I have forgone my earlier submission.
And that we want it on record. It's not there. Bring it on record by way of an affidavit. We'll pass order.
Standing item 27.
Yes.
In this case, I'm appearing on behalf of P. Sharma Lordship. So he's, due to his ill health, he could not file
No,
the
no,
appeal.
somebody, MS Sutia on the last date appeared on behalf of P. Sharma and director in short time.
P. Sharma, he suffered stroke, Lordship. So he needs some,
Have you seen the last order?
No, Lordship.
Why don't you see the last order before you make submission? We have recorded her name. She is appearing for respondent 1, 2, 3. P. Sharma appears for whom?
Respondent number 1, Lordship.
Yes, yes.
Only
1.
one.
4
Only
is
one.
appearing, 4 is.
4 I am appearing.
Who's appearing for 2 and 3? 2 and 3?
I have no knowledge, Lordship.
So,
I think Ashwitya appeared on behalf.
S. Sutia appeared. Where is he? Yes,
She is
Mr.
in court, Lordship.
Huh?
She is in court, Lordship. I'll just inform her.
No, she appeared on behalf of P. Sharma only, Lordship.
We had sent a scrolling. Why it is not there? In spite of second call, counsel who represented respondents 1, 2, 3 on the last occasion, as is reflected in the order dated 2008-2025, is not before the court. On the last date, the said counsel representing respondents 1, 2, and 3 was permitted time to complete her instructions and to file show cause reply. And to file reply. However, today, in spite of second call, the counsel has not appeared. Instead, Mr. K.D. Sharma has appeared before the court representing Mr. P. Sharma on the ground that he is indisposed. Mr. H. Aliha appears for respondent number 4. 4.
Yes, Lordship.
Under such circumstances, we are constrained to request the presence of the senior government advocate, Mr. D. Nath to assist the court on the next date fixed. The list on 10th December. Copy of this order be marked to the office of Mr. D. Nath, Senior Government Advocate. And copy of this order also be placed before the Registrar Judicial. List accordingly. Mr. M.P. Sharma for the petition.
For hearing item 46.
May it be lost, Madam. Here in this departmental case, Madam, proceedings, the basement of the case was based on the FIR at page 19 and Excel 1, my lord. My lord, since that is the foundation, may I take a lawsuit to the FIR?
Page?
Page 19.
19.
19, my lord.
Yes. Yes.
Just a moment, my lord. 19, yes. Here the, with due respect to so on 27/7/19 in the morning with the Bureau mentioned accused called my sister-in-law Tara Bhanu, 11 years in his house for cleaning utensils and he raped. There is the allegation, my lord. FIR was filed on 31/7/2019. Incident is of 27/7/2019. That was the best one. Now I'll also kindly come to charge sheet. Page 24.
Uh, 24.
24, my lord. First so called that is charge sheet. It's Annex 3. You'll also kindly read the first paragraph itself. You are hereby directed to show cause under section 65. It is not section, it should be rule 65, Assam Police Act 2007, and rule 66 of the Assam Police Manual Part 3 and 311 of the Constitution of India, and rule 7 of the Service and Discipline Rules 1964. Now you'll also kindly come to police manual first. Police Act, police Act, police Act, Part 3, my lord. Page, my lord. 417 is in my book, my lord. मैंने 1861 65 rule 65 my he is also got my lord. Part 3 of the police manual 1861.
Hmm. $65. Yes.
65, my lord, is after conviction. And 66, my lord, where the proceeding is. What one? Yes, my lord, here in this book. 66. Yeah, that's okay. Block. Wait. Yes. You'll also only read 66.
The same procedure as prescribed under discipline and appeal rule.
My lord, but the 66 is relevant to police, my lord. First kind is 66. The appointment of police officer is not. Following penalties may be imposed. Major penalty. Dismissal of service which shall be ordinarily be a disqualification for future employment. Removal from service which shall not be. You also skip that. And then you also come to government of Assam or the central government or any other state government or local or so, whom to whom service of government servant has been lent. So. Then there is a word conviction. What is that?
Proceeding based 65.
No. Sub-rule 3. No order of major punishment shall be passed on a member of the service other than order based on facts which have led to his conviction in criminal case, unless he has been informed in writing of the grounds on which he is proposed to take action and has been afforded opportunity of defending himself. So, my lord, here since the charge is based on criminal charge, my lord, criminal proceedings. So, my lord, either they could wait till the criminal proceeding over, my lord. Otherwise, my lord, rule 65, after conviction, my lord, rule 65 automatically comes. Just the lords will see 65. Proceeding based on conviction. When the police officer is dismissed or Department of punishment is inflicted on the basis of a charge for which the officer has already been tried and convicted in a court, it shall be sufficient in proceeding to give a copy of the judgment and reasons for inflicting Department of punishment and the various previous character of the officer concerned. So, my lord, here conviction is yet to follow, trial is going on. Then also I will come to Assam Service Division rules. You have said rule 7.
Why did you point out to rule 66?
Yes.
For what purpose?
My lord, there, since it is the proceeding initiated on the basis of FIR.
Huh?
FIR.
Yes.
But FIR, I'll take a lawsuit further, my lord. What is there in the FIR and what is in reality? Hey, to my instruction, it is total made out case due to some enmity regarding key because.
No, the question is not that. The question is you are given an opportunity to adduce evidence.
Yes, I am coming, man.
The
I am coming to
cross-examine the
this.
defense witness. You
Yes.
refuse to do it.
Yes. Then they have also cited under Rule 7 of the Disciplinary Rules 1964. That prescribes only the nature of penalties, my lord. Nature of penalties, Rule 7. It does not prescribe the procedure. Procedure, once you rely on, my lord, 1964 rules, then the procedure you will have to go to Rule 9. It is mandatory.
Yes.
You will also kindly come to Rule 9. Here is my case. Without prejudice to the provision of the Public Servant Inquiry Act 1850, no order imposing on a government servant any of the penalties specified in Rule 7 shall be passed except after the inquiry held as far as may be in the manner hereinafter provided. The disciplinary authority shall frame definite charges on the basis of the allegations on which the inquiry is proposed to be held. Such charges, together with the statement of allegation on which they are based, shall be communicated to in writing to the government servant and shall be required to submit within such time as may be specified by the national authority a written statement of his defense and so also to state whether he desires to be heard in person. Then the amendment of 1978, my lord. At the time of delivering the charge, yes, 1978 amendment, my lord, in Rule 9. At the time of delivering the charges, the disciplinary authority itself invariably furnished, the word invariably, furnish to the government servant a list of documents and witnesses by which each article of charge is proposed to be sustained. All this one. Here, Mahalir, while delivering the list of documents witness Mahalir, will also kindly turn to the next page of the charge sheet. Page 25.
Yes.
Here, list of witnesses, there are 3 witnesses. If a lawsuit, I'll take lawsuit through the inquiry report also. He has relied on 9 witnesses. They beyond the record mark. They cannot be done. And in the list of
But how do you explain your conduct of not cross-examining? You refuse to cross-examine.
no, but if they fail to maintain the mandatory provision of to follow mandatory provision
We
of
are
law.
not sitting in appeal. We have to see whether the procedure.
No, I am on simply on law point, my lord.
Ah.
In writ
So
peti-
therefore, it is not, see, how do you say
Yes.
that relying on 9 witnesses instead of 4 or 5?
And 5 witnesses.
5 witnesses.
Yes.
Has caused prejudice to you.
Yes.
When you refuse to cross-examine any of the witnesses relied upon by this.
It is true, my lord. But they cannot induct anything outside. There is a judgment of this court matter by Lordship Joseph Bhuiyan based on 1971 Supreme Court. I have not brought that one today. And in the list of documents, they have only 3.
Subsequently, there are several judgments of the apex court where what is to be seen by the court in judicial review is the prejudice that you have faced. You have to say that what is the prejudice
My
you
lord,
have faced.
no, even if it
by
is,
relying
my lord,
on
no.
certain.
Even if it is ex parte, my inquiry environment, they are to follow the rules.
This is a, Mr. Counsel, this is a procedure.
Yes.
The purpose of the procedure is to ensure that you do not face hardship or prejudice. Now you show us how by relying on 4 or 5 other witnesses, you have suddenly faced prejudice when you refuse to examine the witnesses, including the complainant.
My lord, your lordship knows in police department, my lord, the police or CRP, parliamentary army, my lord, we are to bound to sign wherever they ask to sign. He is a constable only.
No, no, bound to sign
Yes.
is one thing.
He cannot challenge. He cannot challenge question also.
Then
Now,
on what basis?
I am on the my lord procedure prescribed under law. Instead of 3 documents, if he produces 5 documents in the inquiry, my lord, that is in violation of the whether I examine or not.
With all respect, we'll have to defer that this violation on the face of it can't be. It must be relevant. It must be that on these 3 or 4 documents, no case was made out. The case was built only on the additional 2 documents which was placed, which was not served to you. Then it is a violation.
Yes. No. I do not know, my lord, what was the document then prior to trial started, proceeding started. I must be informed that these are the documents. Whether I would like to cross-examine or not, it is the duty to, my lord, produce the same documents and same witnesses.
Where are the records, Mr. Sutia?
Yes,
Show us from the records what opportunity was granted to cross-examine.
Yes.
The complainant, what opportunity was given to the delinquent to cross-examine whether any
Yes,
application is there, not there.
Yes, my lord, he was, the charge person was given chances to question the complainant.
No, this is available in the inquiry report which we have it.
Yes.
We are asking you for the records of the proceedings to show how the proceedings was conducted. There must be a procedure noted on a day-to-day basis when the examination, when the proceedings took place.
My lord, he refused to, my lord, say anything.
The lordship will kindly go through the order sheet also, what the works. And further, my lord, it is the duty.
Yes, statement of allegation, all these things, he has put his signature, that was shown to him. And he denied to, my lord, so to SP, all these things are there, my lord. Statement of allegation, he put his signature, so course, put his signature, all these things are shown to him. but he refused to say anything, my lord. Say anything. But it is a case of, my lord, not other IPC only.
May I also
It is
go
a
to the record?
POSCO case, my lord. POSCO case is very serious. I will pass a.
That is
They
for the
will
trial
try.
court to determine.
Yes, time code will determine,
Ah.
but in this case, my lord, this is a departmental proceeding. Departmental proceeding cannot be, my lord, not need not necessary to prove beyond reasonable doubt. It is a criminal court. They are business, my lord. So here, preponderance of probability, the case has been
Is
established.
there any admission that he is committed?
Yeah, admission means he denied it, but
No, no, I have in my written statement as well as, my lord, WS2, the inquiry report I have denied. It's totally out of enemy due to rent. There were delay in payment of rent. And interesting matter, one thing, Your Lord, the FIR says 11 years old girl. The FIR says 11 years old girl. Now you'll also kindly go to page 36, 37. The medical report and injury report.
It come to page number 33.
33.
Yes.
Yes, my lord.
Then serial number 6.
6. Further, it is seen through the process of the DP that the charged personnel have not cooperated with the investigation and senior officers. He has absent from his duty post and hide his whereabouts. So,
Where is this conclusion arrived at? On what basis?
further, my lord, on the basis of the witnesses, my lord, given by the victim is there and also my lord, complainant.
Read 6, it says, during the progress of the DP.
Yes.
Is it noted there in the record somewhere?
No.
That he failed to cooperate?
This is the inquiry report, my lord.
I know this is the inquiry report. The inquiry report, right, gives reflects the finding of the inquiry officer. So on what basis was the finding arrived at? Is it available in the record, some material?
My lord, statements are there. Statements of witnesses are there, my lord. Doctor's report is there. These are the my lord, statement of the complainant, these are victims.
You have not gone through the record properly.
No, my lord, I have seen.
No, please go through it properly. Tell us on what basis this conclusion has been arrived at by the inquiry officer.
Further, so Abdul Razak Mandal was released from judicial custody on bail and revoked from suspension. Currently, he is deputed to the office of the Inspector General and performing duty with the IGP. During inquiry, the charged person was given chances for cross-examination, but he has nothing to say as he had already given his statement to the previous inquiry officer. He's under the fruits and facts and circumstances on the merit of the sufficient evidence on record, the written reply as well as the statements of prosecution witnesses, the charged officer of the gross immoral conduct, indiscipline, and dereliction of duty brought against UBC, Abdul Razak Mandal of the is proved beyond doubt. So statement, the exhibit, so and so, all these things are there. There is no lapses, no irregularity in them during the department proceeding.
But where is the conclusion arrived at?
Conclusion, my lord, these are the inquiry officer. Inquiry officer says this is a proof.
You signed on papers because your superior officers wanted you to sign, Mr. Sharma.
Yes.
But that is not a ground you have taken in appeal. How do you propose to support this contention?
I will, of course, in my WSO, no? In the appeal, I've said that, my lord, I was not given chance to cross-examine.
No, that we have said, but you did not say that you were forced to sign in papers or you were compelled to sign in papers because your superior officers wanted you to sign in papers.
That is the instruction, my lord, orally received. And FIR was not exhibited, neither the medical report, my lord, but medical report we have annexed, my lord.
What is the stage of the criminal proceedings, Mr. Chutia?
My lord, I don't have this, my lord, information.
What is the stage of the criminal proceeding?
So, yes, my lord, some witness seem to be biased, my lord. So he filed the criminal petition in High Court for recalling the witnesses, recall whole, pending us. If you'll also kindly come to medical report, my lord. Is 36, 37.
No, we've seen that.
And my lord, interestingly, I again have to take a lordship to that injury report, my lord. Page 37, my lord. What the doctor said on the everything is normal, my lord. Recovery, secondary sex character developed. Breast was well developed, both sides. Local examination, linear abrasion marks in the seen over the chest, upper part. That and one more.
Give us their judgment.
Yes. And they cannot rely on anything beyond the records in the proceeding.
They have not relied on.
Well, 7 extra witnesses they have brought.
Where have they brought 7 witnesses?
Yes, second
Show us-
witnesses.
Show us from your documents.
Sorry, exhibits. 7 exhibits extra.
Where?
Yes, page 32.
Page 32, I'll tell you what
Secondary
page.
exhibits.
No, my limited understanding of page 32
Yes.
is that page 32 are the statements which are made before the inquiry officer by the 5 witnesses which are enclosed here.
Yes.
And over and above that, the exhibit 6 is the statement of the charged officer.
Yes.
Exhibit 7 is a report
Yes.
regarding the status of the
OC.
case. These are not extra documents. These are the same documents. These secondary exhibits are on nothing but the statements given before the inquiry officer which are enclosed to the inquiry report. This is my understanding.
Yes.
But my lord, while giving the inquiry report, these statements should also given to me so that I can deny. So that in my second show cause I can deny it. They have not furnished. Only inquiry report is
Second
given.
so cause, my lord, inquiry report is furnished to her.
Yes.
So the
What
inquiry
is
report-
inside
the
those
reply is
documents, 7
there.
documents, 7 exhibits, secondary or primary?
Have you asked for all this before the appellate court? No.
They did not ask.
You filed an appeal. You did not say that
My
this is
lord,
mandatory, we want it.
I am not a constable, right?
Oh.
Anyway, but my lord, it is their duty to give. Whether I ask or not, since they have relied it on in the inquiry report, they are bound to give the along with the inquiry report. What is there inside?
You were given opportunity to examine all these documents.
I was given opportunity to examine those exhibits, my lord, listed documents.
After the statements are given, was it not in your presence?
It was not in my presence. Yes.
Mr. Sutia,
Yes, my lord.
please tell us what is there in your records.
My lord, record says, my lord, records, whatever the statement or allegation is there and witnesses, they are examined. And all the witnesses in presence of the petitioner. If petitioner,
You show us from your records that these were the procedure followed. It was confronted to the petitioner. He has put his signature.
yes, my lord, record it. These are the, my lord, these are the statements of the witnesses in presence of the petitioner.
You have signed it here.
He put his signature, my lord.
Yes, I will ask to sign, I have signed. I have signed, wherever I will ask to sign.
Now, how do we now say that? On what basis will the court decide that this signature is under compulsion? What is the parameter to decide that?
And we have taken this, my lord, the ground in our prison also, paragraph 11. So, whenever, qualification.
No, you have signed.
Yes.
Now your case before the court is that this was under compulsion. Now you tell us on what materials or what parameters will this court come to a finding that this signature was not voluntary but under compulsion.
That of course we have not said anywhere. We have not said anywhere. That apart, I am on the totally on law point regarding this outside materials, and I'll produce that judgment also, and also the judgment, my lord, of this court, single bench judgment, that sub-rule 5 has to be followed by them whether I ask or not.
Yes. But
Yes,
let's
sir,
stay
first
after
one.
tomorrow for further hearing. As it is submitted that the council the
Day after
petitioner
tomorrow, my
would
lord.
like to
Day
refer
af-
to certain judgments.
Day after tomorrow.
Day after tomorrow.
Let's go. 8 to 8 to again, madam, after.
Day after tomorrow.
Yes, sir.
Sir R.P. Sharma, Senior Counsel, assisted by Raj Chaudhary, Mr. T.C. Sutia, learned additional senior government advocate for the response. You may take back the records and keep
Yes,
it.
yes.
The records
I will
received
check again, my lord. I will
will
check.
be kept with the government officer, government council.
Item 47.
Matter relates to reduction of the pay of the petitioner in the last month. It has been about 4,000 rupees, which has been reduced in the last month of his pay, having an effect on his pension for his entire life. Now, Lordship, reduction of pay has two elements. In my case, two elements have been taken away from my pay. First is the financial upgradation benefit, which was granted to me on 1/1/2007
and has been taken away. On this aspect, I had made my submission on the last occasion, Lordship. I shall recapitulate, Lordship, at the later stage. And the second aspect is the promotional increments. With respect to my
We have heard the matter. Anything further?
further, Lordship, second aspect, I have not made submission. He has made submission.
What is the second aspect?
The promotional increments.
Huh.
Promotional. First aspect, Lordship, the financial upgradation benefit granted to me on 1/1/2007 and taken away, Lordship.
Huh.
That I shall
Which
recapitulate.
according to them is no higher responsibility.
No, not that, Lordship, not that. I'll clarify, Lordship. First aspect, financial upgradation benefit, it has no connection with higher responsibilities. It has no connection with increments. It has no connection with FR. Then, Lordship, I shall start with the first aspect. I shall not take much time because it is already.
They've already heard you.
Yes, Lord.
We want to know
Since some clarifications
what
are
clarifications.
because the first aspect, financial upgradation benefit has no connection with increment. That is the second aspect, Lord.
What is your reply to that?
Fine.
What is your reply for withdrawal of financial upgradation?
Yes, ma'am. Lordship will take up that page 93 document, ma'am. Not 93, 88.
Yes.
And simultaneously, Lordship will also have to take up page 116, that office memorandum.
116.
Office memorandum.
Yes.
I'm reading the middle portion, madam.
Of
page 88.
Oh.
After checking of time to time pay fixation of the incumbent, it is observed that the incumbent was promoted to the post of senior peon on 1/7/87, service book so and so, allowing one promotional increment which is irregular as per office order dated 10/12/2004. This, my lord, again I'm relying on FR 22, my lord. Again, the incumbent was promoted to the post of typist. Now here he contends that this is a direct recruitment, not a promotion. In the office of the chairman, write office order number so and so dated 13/10. Moreover, the incumbent was allowed scale benefit on 1/4/97 in the scale so and so, and financial upgradation benefit on 1/1/2007 on completion of 25 years of service. This is that is the incumbent was allowed 4 financial upgradation benefit in all, which as per the office order number so and so dated 1/10/1990 and clause 6(2) of the office order dated 30/12/2006. Now, for a moment, if we come back to that clause 6(2) of 30/12, my lord, that will lordship will find at page 118, my lord. Why he is contending that it is a direct recruitment? Because 6(2) says that an employee who has already got under the next higher scale scheme of 90 2 regular promotions or 2 similar benefits of higher pay scales in case of isolated or blind alley posts, as on the date of implementation of the scheme, shall not be entitled to get any further benefits under this scheme. So he has received 2 promotions. That is why his contention is that it is a direct recruitment. So if he has got 2 increments, then the financial upgrade, he will not get more than 2.
So what increments did he get?
Here, at the time of first sentence, my lord, incumbent was promoted to the senior peon, allowing 1 promotional increment. Then the increment promoted to the post of typist. There also he got another increment. Again, moreover, the incumbent was allowed scale benefit of 1/4/97 and financial upgradation on 1/1/2007 on completion of 25 years of service. That is, the incumbent was allowed 4 financial upgradation benefit.
He's under the scheme, he's allowed how many? 2?
2.
2. One first upgradation will be?
On completion of 15.
15 years.
Yes.
Second after 25.
10. Sorry. Page 117, 10 years. And then on 25 years.
10 and 25.
But if he has got 2 promotions, then 6 subclause 2 will come.
So no benefit.
No, that makes sense.
Yes.
Yes, I shall clarify. Now my fresh appointment to the post of typist is dated 13/10/1988. That order is at page 30. So from 1988, if I see, Lordship will see para 5. I'm covered by this, para 5A. From page 117, the financial upgradation scheme. In accordance with the norms laid down in para 4 above, an employee completing as on 1/1/2007, 10 years or more, but less than 25 years of service shall be fitted in the pay scale of the first next higher promotion grade post in the service in which the employee belongs. Meaning thereby, I have completed 10 years, but less than 25 years as on 1/1/2007. This is operative on 1/1/2007. So as on 1/1/2007, I will get one financial upgradation benefit, counting from my fresh appointment to in the post of typist.
But
on
this particular scheme itself suggests it's for employees who are not entitled to, I mean, who does not get the promotion.
Yes. Lordship will see, my appointment to the post of typist is a fresh appointment. I shall show your Lordship the order. So fresh appointment is dated 13/10/1988. So it will start afresh from 13/10/1988.
Oh, they say this is promotion. You say it is promotion.
Yes.
My lord, if it is a direct recruitment, then his services shall have to be now recalculated from 88. Prior service is gone.
No, but according to you, this is.
It is a promotion.
Yes, from 1988 till 2007, 1/1/2007, I have received no promotion.
No. If your appointment is a fresh appointment, then your service benefits.
Prior to 1/1/2008, prior to 1988, it is immaterial. I am not concerned with that, Lordship. From 88, he has served till 2021. He has qualified the pensionable service. Everything he has. He is not after seeking for his past service benefit. It is not required also, Lordship. It is a fresh appointment pursuant to an advertisement, pursuant to a selection. And I will show the order, Lordship. It will clearly show that it is a fresh appointment. So from 1988 till 2007, 1/1/2007, no promotion I have got. So accordingly, they have themselves granted to me on 1/1/2007 a financial upgradation. Now they have taken it back without any behind my back. Now they say my promotion to senior peon, that is one financial upgradation. Then they say promotional increment is a financial upgradation. Then they say typist promotion is a promotional upgradation, and accordingly for that reason they have taken away my financial upgradation on 1/1/2007. Now for a moment, Lordship will see determine whether it is a fresh appointment or not. Page 30, the order. Page 30 is the order. And very interestingly, Lordship will see the post which I was holding prior to typist. This is interesting, Lordship. The post I was holding prior to typist is senior peon. And I assume charge in the post of senior peon on 1/7/1987. 1/7/1987, I became senior peon. So how can I get a further promotion within 1 year itself, Lordship? It is not possible, Lordship. Lordship will see page 30, order. Subject
Which
to.
is the impugned order?
Impugned orders are many, Lordship. Impugned orders, page 88. 88, then 90, 91, and 93. Lordship will see my appointment order to the post of typist. The order will clearly show it is a fresh appointment. Page 30, I am reading, Lordship. Subject to satisfactory police verification report on character and antecedent and submission of medical fitness certificate, the marginally noted persons are appointed temporarily and until further orders as typist. Now, Lordship, there will not be a police verification or character antecedent medical fitness certificate in respect of a promotion. It is nowhere seen that in promotion, medical fitness, police verification is seen, that too in the case of a typist, for promotion to the post of a typist from senior peon. Then Lordship will see this order not only has departmental candidates, it also has outsiders. So department candidates and outsiders cannot participate in the same examination for promotion or appointment, whatever they say. For departmental candidates, they are supposed to hold separate limited departmental competitive examination if need be. And for fresh recruitment, it will be a direct recruitment examination. So regardless of whether we are departmental or outsiders, they have all participated as fresh candidates. Serial number 1, serial number 3, and serial number 4 of page 30, these are outsiders. I have stated categorically at page 125 that these are outsiders.
Where is the OM dated 3012? 2000. This is annexure 2.
That he has, my learned senior friend just now read page 116. That is the financial upgradation benefit scheme.
No, but there's something else written here. Clause 4D.
4D at page 117. The post of LDA cum typist in the HOD office meter to which they are appointed as such against departmental reservation on the basis of departmental test shall be treated as promotion post for the purpose of this scheme.
Yes. There is a scope for departmental promotion also to the post of typist. And this is not my case. This is not a case of promotion by a departmental examination. Then if it is a departmental examination, how have these outsiders participated in this examination? And how have I, only with less than 1 year in the feeder cadre, allowed to participate in the departmental
Where is that advertisement which you
It
applied?
pertains to 1988, Lordship. I have categorically asked him, it is not available with him. Then a recruitment test was also held. Lordship will see page 136.
Do you have it in your records?
That
must
we'll
be
have to-
there.
That we'll have to verify.
You give us that advertisement, let us find out what is written there.
If there is at all as an
There
advertisement.
must be.
There must be.
Lordship will see
Because there is
130
nothing in the pleadings, my lord, that it was pursuant to an advertisement.
Lordship will see, I have stated is a direct, 134 Lordship will see, 134. Individually, they have called me for selection test.
That's right, we want to see that advertisement. Why it should be there somewhere?
All these are very categorically clear, Lordship, that it is a, then Lordship will see, Lordship, page 30, Lordship will see. There are several elements. First of all, Lordship, nowhere it is mentioned promotion, page 30 order. Page 30 order, it is nowhere mentioned promotion. They have mentioned it is an appointed. Page para 3, Lordship will see. Marginally noted persons are appointed temporarily. Then Lordship will see this police verification, medical fitness aspect. Then Lordship,
You have to bring that advertisement to tell us what is the manner in which they were recruited. There must be some reference. If the advertisement is not there, maybe some reference. On what basis are you taking away the claims which he's asking?
I'll get back to you, Lordship. I'll have to take my.
Only on the presumption that this scheme does not permit.
And relying on FR 22.
No, FR 22 is regard
Because
to
his
second
service
aspect.
book says so, my lord.
The service
Service book is maintained by them. I have no role in
Service
maintaining of
book
a service book, Lordship.
is maintained by you, that's
Yes.
right. But on what basis were these people recruited? That will give the answer to all these issues.
Because
The
if
core issue is whether it was a promotion or
Because
an
if it is a direct recruitment, then that 6-2 will not come.
appointment.
But if it is a promotion, then 6-2 will
Then
come.
how do we know that whether
Yes,
it is
my lord, yes, I follow.
let that advertisement be there, point it out.
Advertisement or notification, whatever it
Whatever
may
is
be, they
there.
are calling candidates to appear.
You don't have any.
Lordship, I have asked him categorically. This is like with much hardship. He has.
Where is your-
Yes, now
Where is your service book?
Service
They
book
have
relevant portion is at 113.
now he's a retired employee also.
Where is the service book otherwise? With the office?
Is the office. They have provided me with the
And these benefit they
page
have
114 and 115 extracts.
Lordship, service book, why it may not be relevant? Because till my date of retirement, they have granted me this benefit. On 1/1/2007, they have granted me financial upgradation benefit, and they have continued to remain it with me till my date of retirement, till September 21. And in September 21, they have taken it back. September 2021, they have taken it back. And this is the first aspect, financial upgradation benefit. Second aspect relates to my promotional increment with regard to 3 of my promotions. That
See, number one is that we need to have a copy of this advertisement or notification, whatever is there, so that we know what was the position then.
Yes.
Number two is your submission that the manner in which you are appointed cannot be termed to be promotion because of these features of police verification, etc. Per se does not mean that it can never be promotion. If the authorities require, they can always impose it.
yes, yes. But it is not a case that I am seeking for or praying for that financial upgradation. They have held it to be a regular appointment and granted me that benefit, and they have themselves taken it away. So it is their burden. Why they have taken it away? How they were
relied on FR 22.
No, FR 22 is not in this regard. FR 22 is promotional increment.
Ah.
Lordship may, with all humility, I submit, Lordship, this aspect regarding financial upgradation has no connection with FR. FR, Lordship, I can come to that aspect, Lordship. If your Lordship permit, FR is the second aspect. That they have taken it away from me, the promotional increment. If your Lordship permit me, I can come to that aspect also. This is
No,
the first
let us
aspect.
first deal with
First.
both issues are mutually exclusive.
Exclusive.
Then
Though-
let us
both-
have an answer to one issue
Yes.
first. Let
Yes.
us understand how
Yes.
your entry into the service was made.
Yes, yes.
Mr. Deka, when can you give it? Before we forget again. 1 week's time, I think would be.
Let us try, my lord,
Ah.
within a week.
Let us have it on 12th. 12th February or 12th December?
Oh, this is 2026.
25. 12th.
No, I was looking at the 26 calendar. my lord. 12th.
Friday.
Can it be on 15th, my lord?
15th may be difficult last week.
That's
Let us have it on 12th
12,
or on 11th.
11, 12.
11.
12, there is a matter fixed, but
All right, we'll have it on 11th then.
let us 11.
11th.
11.
Matter be listed on 11th. Again, for further hearing, on which date the standing council ABCL will apprise the court with regard to the manner in which the post to the post of
Typist.
the mode of recruitment to the post of typist in which the petitioner secured the recruitment and process undertaken stop. According to the petitioner, it was a direct recruitment, whereas the department maintains the stand that is promotion. The appropriate advertisement or notification published by the APDCA to that effect is necessary. Mr. Deka is therefore permitted to complete his instruction.